No, sir.
Okay, well, we can get started.
Thank you and good morning. I would like to start out with the supplemental legal report that I would have given you all. It's a two-page document there, and I think this may take us a few moments to discuss. So I would like to start out with that one. This is starts out with number 1A. If everyone has that in front of them. Case number 2013005961. Here, the complainant alleged that the respondent, who was a dealer, knowingly sold motorcycles to consumers that were subject of an open safety recalls before the recall work was performed. The allegations include motorcycles sold between 2007 to 2012. The respondent here primarily deals in power sports motorcycles. The complainant is an ex-contractor with the dealership who managed the daily operations of the dealership until 2007. The complainant states that he is now a safety advocate for the protection of the public. The complainant further stated that the respondent had been found conducting violations by the National Highway Transportation Safety Administration, otherwise known as the NHTSA. This office investigated those allegations and determined that the NHTSA had done an investigation on respondent for allegations of selling hundreds of motorcycles and power sports without first conducting open safety recall repairs. The NHTSA and respondent entered into an agreement whereby the respondent agreed to pay the NHTSA a $125,000 penalty over a 5-year period. However, as part of the agreement, the respondent denied any violation ever occurring. As such, there has not been a finding or admission of violation regarding these actions, only a penalty paid. Next, this office obtained documentation which appears to show that the respondent sold approximately 400 motorcycles without first performing open safety recall repairs. Of those 400, approximately 140 motorcycles still have outstanding safety recalls on them. The remaining safety recalls have ultimately been conducted either by the respondent himself or another dealer. Further, this office was provided 2008 documentation from the manufacturer to the respondent indicating that the respondent had been selling motorcycles without first performing safety recall work. And the bulk of these allegations for the failure to conduct safety recalls was from 2007 to 2008. After 2008, it may have been 4, 10, 3 vehicles over the years. It was the bulk of which was done in 2007, 2008. Approximately 20 of such alleged violations occurred after 2008, as said. The respondent here indicated that many of the safety recall work was performed almost immediately after the sale and delivery to the customer. This appeared to be true, in part. However, under federal law, the respondent was prohibited, and they knew they were, from selling motorcycles until safety recalls were performed. The respondent further stated that many of the recalls required that there first be a visual inspection performed before any safety recall work is determined to be necessary. They indicated that this happened, but what they failed to do was actually record the inspection on the database for safety recalls. However, this has never been substantiated by the respondent with any type of documentation or statement from a technician who would have done this. The respondent further assured us that they had no knowledge of any individual ever being injured on one side from one of the vehicles subject to the recall. Further, the respondent provided a copy of its policies and procedures used to ensure that it does not sell motorcycles that have an outstanding safety recall. This commission has authority to discipline the respondent for the above acts under 55-17-114-B1K, which would be engaging in any type of activity that is considered by the commission to be false, fraudulent, or deceptive. The Tennessee Attorney General's office also has a same claim. They have the same suit that they're pursuing against the respondent for the same actions for violation of the Tennessee Consumer Protection Act, meaning that the Attorney General's office can enforce the Consumer Protection Act, and the same actions or non-actions of not performing safety recalls is also considered to be a deceptive trade practice or similar idea of not providing conforming goods to the public, and the Attorney General's office is pursuing that. For recommendation, the legal division, we have posed around attempts to settle this matter prior to bringing it to the commission, to bring you something that we feel that would be a good resolution for this matter. However, we have not been able to do that, and as such, we have decided not to provide a recommendation to you all, that you all are free to discuss the matter and come up with a recommendation, and we will pursue whatever recommendation that is. To let you all know what we have attempted to do, or what our discussions were, is the first is we looked at maybe potentially doing civil penalties of $500 per violation. That is something that we looked at. We also looked at maybe doing a joint resolution with the Attorney General's office whereby we asked the Attorney General's office to take our claim, since they're already pursuing a claim under Consumer Affairs that is within this department, that we could ask them to pursue our claim so that if they wanted to sue this dealer, that they could take the Motor Vehicle Commission's claim. They did not. They declined to do that when our office asked them. So they said that they would rather us, legal division here at our department, pursue this dealer for our claim for the Motor Vehicle Commission, and they would do theirs separately. We also attempted to maybe do a consent order with the dealer so that we would provide them the ability to not admit fault on their behalf, but recognize that there's a possibility that we could find that there was fault and that they would pay a civil penalty for that amount. And that's probably the most contentious area that we had, is that this dealer is afraid to admit any type of violation on their part for fear of any civil suits that may come later by anybody who would have purchased one of these motorcycles if something did happen. From their standpoint, it wasn't necessarily a civil penalty amount. It was that if they had to admit some sort of fault to settle with the Motor Vehicle Commission, then they were more inclined to have a finding made of fault before they would admit a certain number of counts of fault. We also had discussed possibly doing an assessment of a civil penalty for whatever amount, and then take that penalty and reduce it by the amount that they had already paid to the NHTSA. The NHTSA, they've agreed to pay them $125,000 over 5 years. Because from their standpoint and the way that we looked at it is that they are paying multiple civil penalties for the same actions or occurrence, for the same transactions. They're just paying them to different entities, governmental entities, and there's more that are looking at them other than the Attorney General's office, our commission, NHTSA. One thing that we had tossed around was possibly whatever civil penalty that was issued. And lastly, there was a suggestion by the dealer that they, in lieu of paying a civil penalty, that they would set up a trust fund, deposit monies into that fund, and that fund they would partner with another state organization to run television commercials where they would be advocating for motorcycle safety throughout the dangerous summer months. So in lieu of doing a civil penalty, they would pay for these commercials that would basically promote motorcycle safety to help undo the harm that they potentially caused out there. They have their own reasons for doing that. Probably has to do with some tax reasons. Other things that we had discussed. There had actually even been a discussion as to whether or not the Attorney General's office is actually will cover the consumer protection part of the entire matter, since whatever monies they collect, the Attorney General's office can take those monies and provide them to consumers who purchase these motor vehicles. If they're protected through the Attorney General's office because they have a different authorization and authority. Determination that there was a likelihood that there was danger to the public, but the Attorney General's office has already covered. Close this matter with a letter of warning, letter of instruction, and then on the other hand, the Commission could also say this is revocation of the dealer's license. So these are the items that we discussed, and we could not come to a resolution this week where they could agree.
get the Attorney General involved, and they've advised us that our procedure, rather than jointly with them, I think we should follow whatever the Motivation Commission procedure said we should do. We should do that. You had an obligation for the consumer at this point. Even if we agree upon a penalty and they buy into it, you still may have some consumers out there. But I heard you say that even if you have some consumers out there, then the Attorney General case will protect those consumers. That's my main concern, is later on someone comes up with one of those recalled motorcycles on a penalty, and as long as those consumers are protected, I don't have any problem with that. But I think we should probably have a hearing. That would be my suggestion. We have a hearing. I don't know all the facts. The evidence, and all I know is that they should have known better. They admit they should have known better. That's just my.
Mr. Chairman, I think the recommendation by the staff, I think your statement reaffirms what the recommendation, what is stated in the recommendation from the staff, and that is that, in its opinion, the Commission does have authority over such actions. And I'd like to add to that we are the licensing authority for the sale of motorcycles. I think that the public interest are being served by the Attorney General's office and NHTSA in their investigations. It sounds like it's been quite thorough. We have a responsibility to the consumers of Tennessee to see that they're protected from egregious offenses like we've seen here. If we could, I think, first come to a conclusion that, in support of the statement by the legal staff, that in its opinion the Commission does have authority over such actions and are the licensing authority for the sale of motorcycles in the state of Tennessee. If we could start there, I think so. Would the chair? My motion is that we support the recommendation of the legal staff in its opinion that the Commission does have authority over such actions and is the licensing authority for the sale of motorcycles.
Second it.
How does the chairman and the state feel as to the aggressiveness of any happening by this committee?
Asking me that question, or you?
I'm asking both.
Oh.
You first.
Well, I'm going to direct it to our attorney. I think he can better. He's more familiar with the case than I am, so other than what I've read here. So,
The question is how we would try this before the Commission. Our normal, we would follow our normal procedure, which is, sorry.
Well, I'm concerned with the evidence that is being sent to us on a continuing basis pertaining to this case.
Right. Yes, I think your question is over that. From my understanding, is that the commissioners have been provided documentation from the complainant personally in order to educate you, I believe, on this potential violations that have been occurring. What we would normally recommend is that if we feel that the commission have been provided documentation that potentially could affect your whatever recommendation you would make. So almost at the pool, like the jury pool has been tainted a little bit, is kind of what sometimes it appears to be. So what we can do is we would generally take this type of case in front of an administrative law judge and let them be sit on behalf of the commission, and then they could make a determination whether a violation occurred and issue out those types of penalties or whatnot. Under our procedures, the commission can review that order than ALJ would. So it would be more of a case where the Motor Vehicle Commission would not sit.
Oh.
It does not, but our discussions in the legal division, it does not have to be that way. The commission member, you all as commission members can make your own determination as to whether or not you can make an unbiased decision on the facts that would be presented to you.
I think part of what was said is inconsistent with the recommendation of the staff. If this were turned over to another body to make a decision, ALJ, I think that statement is inconsistent with the statement by the staff that the commission does have authority over such actions. I think we would relinquishing our authority by going on the record and saying that we might have to pass up our decision-making process in favor of an ALJ or someone else.
This is, maybe I could clear some of the confusion, is that the commission itself has the authority over these types of actions or violations. If the commission chooses on any given case, the statute allows for administrative law judge to sit and make the decision on your behalf. They don't sit there. When an ALJ, administrative law judge, sits in lieu of the commission, it is not the ALJ. It's not the ALJ who gets the ability under the Secretary of State's office to make that decision for them. They're making the decision on your behalf. They're sitting for you. You've almost designated them to sit and make the decision for you. So the order would come out from the Motor Vehicle Commission. Their order would be, it's before the Motor Vehicle Commission. It would come out on behalf of the Motor Vehicle Commission, and then the commission, if actually review that order of the administrative law judge, whatever order that they would provide.
It seems to me that what you're telling us is we do have the authority to do it if we want to get involved in this, if we think that they need additional punishment, and it seems like whether the likelihood of danger to the public is important for me to know. If this was just a sloppy paperwork thing, is it something that we want to get into in addition to all the other things they're going through? And it's, from what I think I heard, since 2008, it would be nothing but sloppy paperwork. Is that what you think?
We haven't, I can't answer that positively or not, whether or not the reason was sloppy paperwork. We have not gotten violations did occur, but whether or not it's sloppy paperwork, of course, that would probably be the dealer's standpoint. But we have not actually been able to talk with the actual technician who would have been doing the sloppy paperwork. We have not been able to speak with him yet.
But Commissioner Jackson, we do have a motion on the floor, and it's been seconded. I know we're in a discussion, and
Mr. Chairman, I still have a question here. I've begun to stack up the packages that I receive rather than read them, that concerning this matter that is being sent from the people involved. And I would assume that all commissioners are getting the same package. Is that true or not true?
Thing from the guy down in Georgia.
Are we not willing to address that? I
Was the
guess.
motion seconded?
yeah, I seconded the motion. And
Could we discuss the motion, Mr. Chairman? And then I'd like to say that my motion is not the end all. There's another motion that I would make. Hope that someone on the commission, on the review committee, would make in addition to this. This is just a stepping stone into establishing our the fact that we agree with our legal staff as to we are the authority in such matters. But that's not the end all, I think, which might be my motion might have caused some confusion. That's all that the motion is at this point. And I think there's more. I don't think our work is finished with this motion.
Right.
And I don't know if you're directing your question to me. I do not know if all the other commissioners received the same documentation that you may have already received.
Packages this weekend.
And this was discussed at the last meeting, that this was your authority to look at what they're sending directly to us. Is that the same thing? I mean, they should have proceeded through you rather than going directly to individual commissioners.
That's the way our process works, and whatever would have been sent to you is likely been the same things that we are receiving. So we receive those and we look at those, and sometimes it would add a little bit more to the details as to what happened or whatnot. But for the most part, the documentation that we received from the dealer themselves is the most. As to the questions about whether or not this commission, these 16 persons would be the ones to sit at a formal hearing, the difference between whether it would be the commission members or the administrative law judge, it appears that it's important to you. It does not matter to us, because we would do the same thing no matter whatever recommendation you want to provide us, whatever authorization, whatever you would like for us to do. The legal division will do its best to make that. That means that they won't. We cannot settle the matter with them, and then we have to go to a formal hearing. We will go to a formal hearing. Process as to whether or not it's going to be before all of the commission members, because generally it is before you all, unless you give us authorization to go in front of the administrative law judge. On whatever authorization you provide us.
It's obvious, once we talk before the full committee, it's obvious that we probably will have we go from there from the commission. So, anything else on that item? Okay, we can move on. All those in favor of the motion of whether I was thinking about saying aye. Ayes have it, so ordered, and we can move on.
Chairman, in light of reestablishing authority here, our authority lies in civil penalties and licensing authority. It seemed to me that the public interest is being adhered to by NHTSA and by the Attorney General's office. It seemed that enough investigation has been done to protect the public interest. I think that our legal staff should stay in contact with the Attorney General's office and through NHTSA, if you can, make sure that the agreement made by this this agreement made with those authorities are adhered to. If they're not adhered to, I think we could request a formal hearing. Licensing might come into play, which I think is as strong a medicine for a problem like this as anything when a license is. I'd like to make another motion that instruct our legal staff to follow the agreement made by the respondent and the Attorney General's office.
I second it, Commissioner Jackson.
We could discuss that a little further now. We discussed the motion is made and seconded. I think trying to establish whether or not to have a formal hearing, what type of formal hearing that we have, whether or not there are correspondence that's been going out here, and I too have not read. I just laid on my desk at home and didn't read the stuff. But I think that let's see if this is adhered to, and if the agreements, if this motion were to pass, there won't be a requirement for a formal hearing. And then, so, in the cart before the horse a little, if we get into
I'd like to talk you out of that.
which part?
I don't believe there's, you can sit back and not do anything, and that's very appropriate to wait and see what the other people are doing. But to go on record and say that, I'm not part of that.
Are you suggesting something more proactive?
I'm saying that we need to stay tuned in to what our legal staff is doing on this matter. Now, if they want to pass it off to the other department, I'm okay with that. But I wouldn't want to go into a number of legal issues that develops civilly, and then we testify that we took no part in this.
That's not where that was not the intent. I don't think we're that far apart.
Appropriate for the legal staff to make a recommendation. From what I've seen of it, it sounded like a disgruntled employee or somebody that was sending out all this mail to us, and that they hadn't followed proper procedures, and that it thrown out of proportion because of that. I don't know if that's the case or not. I saw some of it, and I've gotten 2 or 3 big envelopes. I looked at the first.
Commissioner Jackson, I think, Commissioner Clayton, I think Chairman Roberts is just confirming. He's not saying that we can't continue our process if we want to do that. He's just saying that he just want to make sure that our staff stay in contact with the Attorney General office and make sure that whatever the respondent is agreement that they're coming up with, make sure that they follow suit with that. And if it falls apart, it's going to fall right back to us anyway if it falls apart. And I think that's what
I think that's the point I'm making, and I don't think we need to go on record and say that we're going to kind of brush it under the table at the moment and leave it. I think we just don't do anything, period. We let legal continue with what they're doing, but we don't say anything.
I don't think we're that far apart, and I think the first motion saying that we're the authority that passed the authority for licensing provides that that was the intent anyway.
Yeah, I'm for the first one. I'm with you on that. I'm just not up with you on the second.
Read it back, and then let's see if we can. If there's something in here, or
I can reiterate what I think so far, what the authorizations are for. The first one was that the commission has the authority over such actions and is licensing authority over the sales of motorcycles. So that was for the first motion. Was that? Second one was that you authorize a formal hearing in this matter from legal. That there was an authorization for a formal hearing.
that was just my comment. Yeah.
My motion was that the staff monitor this and keep us apprised as to what with the Attorney General's office, and should those agreements not be met, we could take appropriate action.
Delay at this time, is that what, delay any action at this time? Is that what you're saying?
Well, not necessarily. If, for instance, if this motion were to pass and tomorrow the agreement is not upheld, then we could complain, and we have the authority to go to a formal hearing, and we can penalty for this license if that's the route that we wanted to go. That's not a motion, but we always have that authority to.
I think you have that authority whether you pass your second motion or not.
I agree with that.
I just think we ought to leave the second motion out of the picture.
Likely having to sue this dealer.
That's my point, and we don't want to be limited to any agreement that has already been made or may have been made that we're not aware of. So, motion that directs us to some settlement here. I think it'd be inappropriate.
Well, that's accurate. We don't.
I don't think that was your recommendation.
No, I think it was just merely to monitor it and keep us posted. My thoughts were that
I think our legal and staff are obligated to do that anyway without us saying anything.
well, without filing a complaint, without the Motor Vehicle Commission filing a complaint,
Already are, well, we talk weekly. The persons at the Attorney General's office and in my office, we talk weekly. As to any changes or how we're moving forward or whatnot. And I wish I could have brought you a recommendation today, but we were so far apart between the dealer and us that there was nothing that we could come up with that would be a good recommendation for you all. So from our division standpoint, and this came from my boss, our general counsel indicated that we would let you all make a recommendation, whatever you all want us to do, whatever that may be, we will do that.
let me ask this question as a matter of procedure. I ask legal staff. If there's some angst about putting this in a motion and having it on the record, this second motion, would it be that the chair could just instruct the staff to keep the commission posted as to
Second that if that's a motion. I'll second that if that's a motion. I mean, I think that's, we don't really know enough about it to.
if staff thinks that's appropriate at a later time, I'm jumping forward. I'm playing it forward here. But
Motion needed for that.
record is saying that, I think that's appropriate. So, with that encouragement, I could withdraw my motion.
I withdraw my second also, like Mr. Jackson does. It's going to adhere to what Chairman Roberts just said and what the report that you just outlined said what our duties are anyway.
Probably when the legal report comes in, I would speak to that and
said it was going to be a lot of discussion then from the beginning. Okay.
all right.
All right. We can move on to the next.
The legal report itself is the next document that we'll look at. Customers to purchase a service coupon booklet for that costs approximately $349. Customers were contacted by our investigator, of which a majority indicated that they did not realize that this was purchased. A few customers indicated that they knew and had agreed to this charge for not have customers. The dealer did have customers who actually used this coupon. However, the investigation found that numerous customers indicated that we're not aware. Office has already been in contact with the dealer, and we made an agreement. We came by with an agreement, which we would like to pose to the commission, which is the authorization for a civil penalty in amount of $60,000 to be set.
Hey, you ready? Okay. All right. The staff has made a recommendation on case number 1. Is there any comments?
Proprietorship assaulted him after he reneged on an agreement. However, the respondent's criminal record was obtained and found that he was previously convicted of a felony, of which included crimes of moral turpitude. We then went onto our database system and found that the respondent had applied for a dealer license in 2012, at which time he indicated that he had never been convicted of a felony, which was a false statement to the commission. A separate false statement on his application, we recommend authorization for the revocation of the purchase price of vehicles purchased, and therefore more taxes were owed by the complaint. Allegations involve tax exemption issues. The Tennessee Department of Revenue would provided no further information regarding pertinent facts or basis for discrimination. This allegation and relief requested is not within the authority of the Motor Vehicle Commission. The Commission command violation of discrimination as is non-enumerated in our statutes. For relief, the case number 20130064881. Here the complaint indicated that her vehicle caught fire and was a total claim loss. She alleged that the manufacturer was sued by her insurance company, alleging the vehicle had a known safety defect. It's further alleged that the dealer who abandoned its licensed location in 2012. An investigation was conducted. The respondent was located at an unlicensed location across the street from their abandoned location. The respondent provided a sworn affidavit saying that it had not sold a vehicle since July 2012, was in the process of applying for a new license at that new location. Subsequent to this, the investigator found that the complainant provided them with a bill of sale showing that the respondent sold a motor vehicle from the unlicensed location to the consumer in January 2013, and provided them with a dealer tag since January 19, 2013, which was until at least last May. The respondent provided a false statement to the Commission, engaging in deceptive acts by holding himself as a licensed dealer while being at an unlicensed location, and misused the dealer tag when providing it to the customer. I recommend the authorization for the revocation of the respondent's motor vehicle dealer license. 7. Case number 201200961. Here, an internal complaint was opened against the respondent for allegations of providing temporary tags for salvaged vehicles sold. An investigation was conducted and found the respondent sold salvaged vehicles to consumers. It appeared that the customers knew that they were purchasing salvaged vehicles. This is something that they requested. However, the respondent admitted to providing temporary tags for the salvaged vehicles. Further, the respondent failed to properly maintain its temporary tag log and failed to retain business records. The respondent also admitted to providing more than 2 temporary. Recommend authorization for a civil penalty in amount of $4,000 to be settled by consent. 8. Case number 20130022742 and 2013. Internal complaint was opened upon notification by one of our investigators that he attempted to conduct an inspection on the premises of respondent, and the investigator found that the respondent was employing an unlicensed salesperson. The respondent failed to produce any of its business records or deal files also. Further, the respondent refused inspection and directed the investigator to leave the property. A follow-up investigation was conducted. At such time, the unlicensed salesperson admitted by affidavit to selling not less than 10 motor vehicles. Further, respondent failed to produce any deal files at the second inspection or a week after the inspection. The respondent failed to provide proof of ownership of a vehicle that it had in its possession. After the inspection, the unlicensed salesperson received a salesperson's license. Case number 20130022742 for the unlicensed salesperson, authorization for civil penalty in amount of $500 to be settled by consent order or formal hearing. For case number 20130022742, the motor vehicle dealer, authorization for a civil penalty in amount of $6,000, $1,000 being for the first count of failure to provide business records, $3,000 for the second count of failure to provide business records, and $1,000 for failure to provide proof of ownership of vehicles, and $1,000 for employing a person not licensed as a motor vehicle salesperson. Number 9, case number 20130011351 and case number 20130011352. The complainant was a consumer who alleged deceptive acts on part of the respondent dealer. The complainant alleged that she paid $390 to hold a vehicle at respondent's dealership for what she considered to be 30 to approximately 45 days was the agreement. The respondent sold the vehicle that she was looking to purchase 17 days after taking the $390 fee. Approximately 41 days after paying the $390, the complainant went back to the dealership and attempted to purchase the vehicle and was informed the vehicle had been sold and a refund would not be given. Investigation was conducted. The only document retained by the respondent by the dealer indicated layaway of a 2005 Kia Sportage for $390. However, the receipt that he gave her indicated that $390 was a payment on a $1,500 account. Further, the dealership manager indicated that the complainant was given 7 days to purchase the vehicle. Contradicting this statement was the dealership's owner, who indicated the complainant was given 14 days to purchase the vehicle. The conflicting stories along with the receipt appear to show that an account of $1,500 was opened, and our opinion is that all of this indicates that there was a deceptive act upon the consumer. Further, the complainant stated during the initial deposit that she dealt with the salesperson and the manager. The manager who she dealt with, who took the funds and wrote her a receipt, was not licensed as a salesperson, but appears to be engaging in unlicensed activity. I recommend that on the first case against the dealer ending in 1351, authorization for a civil penalty in amount of $1,000, $500 for deceptive acts, and $500 for employing an unlicensed salesperson to be settled by consent order or formal hearing on the second case, ending in 1352, which is against the manager, salesperson, authorization for a civil penalty in the amount of $500. Case number 20130072. Alleged that the respondent dealer failed to retain possession of a trade-in vehicle until receiving funding from a third-party financial institution. The respondent admitted to such, but listed mitigating factors, including that the complainant was attempting to rescind the purchase. I recommend authorization for a civil penalty in an amount of $500 for violations of 55-17-114 B4A Romanet 2 to be settled by consent order or formal hearing. Number 11 includes 4 cases: 2013-008131, 2013-008141, 2013-005951, and 2013-009861. For all of those above, the complainant's consumers allege that after the purchase of a vehicle by the respondent dealer, the vehicle began having mechanical problems. There's no proof of any deceptive act by the dealer. The vehicles were purchased as is or with a warranty, of which the denial of a warranty claim was not provided to the Commission. I recommend that we close these. No violations being found. The vehicles were all purchased as is. Number 12, case number 2013006711. Here, the respondent dealer was found employing an unlicensed motor vehicle salesperson at his dealership. The employee had previously been licensed as a motor vehicle salesperson, but such license expired. A notice of violation was issued. The respondent obtained a motor vehicle salesperson license for its employee 6 months later. I recommend an authorization for a civil penalty in an amount of $500 for employing an unlicensed salesperson. Number 13, case number 2013008061. Here, the complainant is a consumer who alleged that the respondent dealer engaged in deceptive acts by failing to disclose a vehicle sold as having been announced with frame/Edom body damage at auction. The vehicle was purchased in 2008. The dealership is now closed. I recommend that we close this complaint. The respondent is out of business. Number 14, case number 2013002521. Here, the complainant is a consumer who alleged that respondent dealer provided her with a false temporary tag, and further that the respondent failed to provide registration. An investigation was conducted. The investigator found that registration was provided to the respondent. The respondent indicated that he had provided a false temporary tag to the complainant, but was under the belief that such tag was allowed, as he purchased it at a Birmingham auction. The tag stated, "This car has been sold by a licensed motor vehicle dealer." The respondent was also interviewed by the Department of Safety and has now ceased providing such tags. I recommend an authorization for a civil penalty in the amount of $500 for committing false acts of providing false temporary tags. Number 15, case number 2013002551. Here, an internal complaint was opened after an investigator provided information that the respondent dealer had failed to correctly disclose Regulation Z financing on vehicles sold with in-house financing. An investigation was conducted and found that the respondent was very honest in his lack of knowledge of the disclosures, and further showed that he did not charge interest on the financing. The investigator provided the respondent with advice on how to correctly provide such information. It appeared, however, that the respondent may have charged the taxes to be paid for, that he may have undercharged taxes to be paid on several bills of sale. I recommend that we close this with a letter of warning regarding Regulation Z and refer the file to the Tennessee Department of Revenue so that they can look at it for possible tax violations. Number 16, case number 2013002721. Here, the complainant is a consumer who alleged that the respondent dealer failed to provide registration and misused temporary tags provided. An investigation was conducted. The respondent admitted that the vehicle was not registered after purchase, stating that the taxes were not paid. However, the respondent did obtain funds from the complainant for the purchase of the vehicle. Further, the complainant provided a temporary tag that had whiteout on it, stating the tag was altered by the respondent. The respondent denied such. I recommend authorization for a civil penalty in an amount of $3,500, $2,500 of which is for fraudulent act of failing to register a vehicle stating the taxes had not been paid, and $1,000 for alteration of the temporary tag. And to refer this matter to the Tennessee Department of Revenue also for possible tax violations on this matter. Number 17, case number 2013002971 and 2013002972. An internal complaint was opened regarding allegations of unlicensed activity based based on a vehicle purchase at an auto auction. An investigation was conducted. The investigation found that the respondent auto auction allowed the respondent unlicensed dealer to bid online for a motor vehicle that was purchased and delivered in Tennessee. The respondent auto auction has since terminated the rights of the unlicensed dealer. The unlicensed dealer attempted to sell the vehicle to a consumer. The dealer has since abandoned whatever business practice he actually had. From the documentation, it appears there was likely odometer fraud conducted by the unlicensed dealer. However, this would require more extensive investigation by the Department of Safety. I would recommend that on case number 2971 against the unlicensed dealer respondent to close with a letter of warning for unlicensed activity and refer the possible odometer tampering to the Tennessee Department of Safety. And for case 2972, who is the auto auction authorization for a civil penalty amount of $500 for allowing an unlicensed person to purchase at the auto auction. Number 18, case number 20. An internal complaint was opened upon information from a county clerk that the respondent, who is an Alabama licensed dealer, was conducting unlicensed activity in Tennessee. An investigation was conducted. An individual had purchased a BMW from the respondent in Tennessee and had difficulty obtaining a title. The Davidson County Clerk required the purchaser to provide an affidavit indicating that the vehicle was purchased in Tennessee. The investigation found that the respondent is a Nashville school teacher who purchased a licensed Alabama dealership, which is run by her husband a few days a week. The husband purchases vehicles at auction, posts them on Craigslist. The respondent provided an affidavit that between 2012 and 2013 they sold 17 motor vehicles in Tennessee without proper licensure. I recommend an authorization for a civil penalty in an amount of $8,500. Number 19, case number 2013-003331. Here, the complainant consumer alleged that respondent dealer engaged in deceptive and false practices during the sale of the vehicle. An investigation was conducted. The investigation found that the respondent had a business practice of not collecting taxes at the time of sale and requires the purchaser to pay the separate sales tax amount after delivery of the vehicle. The respondent refused to process registration until the taxes were paid. The respondent provided an affidavit indicating they were ignorant of the facts that the taxes were paid by the dealer and indicated this practice will stop. Recommend an authorization for a civil penalty in an amount of $2,000 for deceptive acts by failing to register the vehicle while requiring further payments for sales tax to be paid. I also recommend that we refer this file to the Tennessee Department of Revenue for possible tax violations also. Number 20, case number 2013-004781. Here, the complainant dealer alleged that the respondent, who is a competing dealer, was altering the federal required Monroney labels on vehicles for new vehicles. An investigation was conducted. The alteration appeared to take the MSR. The alteration that they were making took the MSRP and added on accessories onto that amount for some advertised price. Under federal law, the Monroney label cannot be altered. The purpose of the labels for consumer information. The respondent agreed to cease altering the labels and ordered new ones. I recommend an authorization for a civil penalty in an amount of $1,000 for engaging in deceptive acts to be settled by consent order or formal hearing.
Question. What is a Monterey label? What is that?
Monroney label.
That is the manufacturer's suggested retail price, the label that is displayed on
Oh, okay.
the window sticker.
Okay. Fancy word for window sticker.
Correct.
Okay.
We'll write that down. Number 21, case number 2013-004771. An internal complaint on information from a county clerk that a consignment store was engaging in unlicensed activity. An investigation was conducted. The county clerk did not retain copies of documentation alleging the documentation for the alleged motor vehicle sales. As such, there was not sufficient evidence to show a violation. I recommend we close this with a letter of warning. Number 22, case number 2013-002541. Here, the complainant is a finance company that alleged the respondent dealer failed to provide title to the consumer who purchased and financed a vehicle with the respondent. An investigation was conducted and found that the respondent did not title the vehicle into the name of the consumer, but had charged the consumer to conduct title work for them. Recommendation, I would recommend authorization for civil penalty in an amount of $500 for deceptive acts of failing to title the vehicle, but having charged the consumer to finance the vehicle, to be settled by consent order or formal hearing. 23, case number 2013-003661, 2013 The complainants are consumers who allege that the respondent dealer failed to provide registration, provided them dealer tags to drive on. An investigation was conducted. The registration was provided to both complainants. The respondent admitted to providing dealer tags to both complainants. I recommend an authorization for a civil penalty in the amount of $2,000, $1,000 per dealer plate provided to the consumers, to be settled by consent order or formal hearing. Number 24, case number 2013003581. Here the complainant is a consumer who alleged that the respondent dealer failed to provide her with the statutorily required conditional delivery agreement after she took conditional delivery pending financing. The complainant also stated that the respondent could not obtain financing on the same terms, that the interest rate was increased. The complainant stated that though the monthly payment amount and the terms of payment remained the same, in order to do so, the respondent amended the trade-in value to obtain a lower monthly payment than originally agreed. The complainant requested the respondent to void the transaction, and the respondent refused. Failing to provide the conditional delivery agreement or failing to allow the consumer to void the transaction are separate violations under 5517-114B4. I recommend an authorization for a civil penalty in an amount of $2,000, $1,000 for each violation of 5517-114B4, to be settled by consent order. 25, case number 2013003641. Here the complainant is a consumer who alleged that the respondent dealer provided her with 4 temporary tags and had not yet received registration. An investigation was conducted. The investigator found that the respondent provided the complainant with 4 temporary tags. The complainant had received registration. The respondent indicated that the 3rd and 4th tags were issued because the complainant failed to return with emission certifications. I recommend an authorization for a civil penalty in amount of $1,000, $500 for each unauthorized temp tag provided, to be settled by consent order or formal hearing. Number 26, case number 20. Here the complainant seller alleged that respondent dealer refused to purchase a vehicle from the complainant after entering into an agreement. This matter is regarding a possible contractual argument and did not involve the sale of a motor vehicle to a consumer. As such, it's best to be resolved by the parties. I recommend that we close this matter. It's a contractual matter between the parties. Number 27, 2013009171. Here an internal complaint was opened regarding possible misuse of a dealer tag provided to an unlicensed person. The respondent filed a police report indicating that the tag had been lost during a test drive. I recommend that we close this with no violation being found. 28, case number 2013011081. Here the complainant is an ex-salesperson for respondent dealer, and he alleged that they failed to pay commissions owed to him. The respondent denied such. This matter is outside the regulatory authority of the commission. As such, I recommend that we close this. Lack of jurisdiction on behalf of the commission. Number 29, case number 2013011381. Here the complainant is an out-of-state dealer who alleged that the respondent dealer failed to provide a vehicle after receiving payment. The respondent provided documentation that they did not sell the vehicle to the complainant. I recommend that we close this, no violation being found. Number 30, case number 2013011371. Here the complainant is a consumer who alleged that the respondent dealer failed to provide registration and provided them with 4 temporary tags. The respondent provided registration after difficulty in obtaining a title and admitted to providing temporary tags. I recommend authorization for a civil penalty in amount of $1,000 to be settled by consent order or formal hearing. Case number 31, case number 2011003091. Here an internal complaint was opened after allegations of unlicensed activity on part of the respondent. The respondent had applied for a new dealership license. The license was granted a few days after the complaint was opened. I recommend close with a letter of warning regarding licensure for each location prior to beginning sales. Number 32, case number 2012023881. Here the complainant is an out-of-state consumer who alleged that the respondent dealer engaged in deceptive bait-and-switch tactics. The complainant ultimately purchased the vehicle requested and advertised, but indicated this was only after being told the vehicle was no longer for sale. The respondent indicated that there was a mix-up between their staff as to what vehicle was available. The complainant was adamant that this was bait-and-switch. Due to the vehicle actually being sold, it would be very difficult to show that there was a bait-and-switch occurring here. I would recommend that we close this with a letter of warning regarding the availability of vehicles advertised. Number 33, case number 2013-000781. Here the complainant consumer alleged that respondent dealer failed to provide registration and requested a separate amount for the payment of sales tax prior to providing registration. An investigation was conducted. The respondent indicated that his policy is that taxes must be paid separate before he provides registration. The respondent provides in-house financing, and though may be paid thousands of dollars for the sale of the vehicle, he will not register a vehicle unless a separate amount is paid for taxes. The respondent indicated that he would mail the title to this complainant. However, the investigator found that the respondent has signs posted in his dealership documenting that each customer is required to pay an additional amount of sales tax before he'll register the vehicle. Under Tennessee law, the dealer is required to be an agent for the Department of Revenue and required to collect sales tax upon the sale, whether or not it's financed in-house or by a third party. Such continuing acts by the respondent are false and deceptive. I recommend for the authorization of the revocation of this motor vehicle dealer's license and referral of this to the Tennessee Department of Revenue for a more thorough investigation. Okay, number 34. These are representations. Number 34 has 7 cases. Number 2012-022-831, 2012-01-8991, 2012-01-010-621, 2012-022-671, 2013-005971, 2010-02-1611, and 2011. Here, all of the above complaints I just indicated were received stating that respondent dealers failed to provide title or registration for vehicles purchased, or that the dealers had been issued a citation which had not been paid. The Commission had previously given an authorization for civil penalty. These dealers have now abandoned their business location or no longer operating. The surety bond information was sent to the complainants previously. I recommend that we close and flag these cases. The respondent's out of business. Number 35, case number 2012-013-111. The Commission had previously authorized a civil penalty for respondent failing to maintain 15 parking spaces for dedicated and exclusive use. The respondent was licensed at this location in 2007 prior to the new rules regarding dedicated parking spaces. As such, this complaint should be closed. I recommend we close this complaint. Number 36, 2012-013-061, 2011-02-3361. Here the Commission previously authorized civil penalties against each respondent who are out-of-country motor vehicle dealers. The dealers are not licensed in Tennessee. The dealer purchased motor vehicles at an automobile auction. Subsequent to the purchase, a motor vehicle was sold or attempted to be sold in Tennessee, where the dealer represented that they were a licensed dealer. There's difficulty as the proof as to who sold the motor vehicle, who specifically sold the motor vehicle. However, the automobile auction should not authorize out-of-country dealers from purchasing at Tennessee auctions without first obtaining sales licenses, dealer's license either in Tennessee or some other state in the United States. I recommend we do a letter of instruction to the automobile auction to remove the respondent's privileges from purchasing vehicles at the automobile auctions. Number 37, case number 2012-000351. Here the Commission previously authorized a civil penalty against respondent dealer for an amount of $76,000, which was in 2012, for failing to log its temporary tag logs properly. Our file does not indicate proof of misuse of temporary tags other than failing to log them properly. The respondent has offered to settle this matter for the amount of $5,000. This office will recommend that amount be accepted based on a statutory violation for failing to temporary tag log can only be prosecuted as one count to a maximum of $5,000. I recommend authorization to settle this matter with a civil penalty in an amount of $5,000. Number 38, case number 2012-003141, 2012-003141, which I just said. 2012-005161 and 2012-008941. I believe the second number is 2012-003142. The Commission previously authorized a civil penalty in an amount of $12,000 against respondent who is a manufacturer/distributor for selling 3 motor vehicles to persons not licensed as motor vehicle dealers. They were selling directly to consumers. The respondent provided us with a counteroffer to be a payment of $5,000 civil penalty and to surrender its manufacturer distributor license, which I think would better protect the public. I would recommend amending the previous authorization for the civil penalty amount of $5,000 along with the surrender of license number 7325. Number 39, case number 2012012551. Here the Commission previously authorized a civil penalty in amount of $3,000 for the respondent dealer advertising motor vehicles at an unlicensed location. The respondent dealer, as part of another case presented in April 2013, voluntarily suspended its license until its date of termination. As such, the respondent is no longer in business. I recommend we amend the previous authorization to allow the suspension of the respondent's license until August 31st, 2013, which will be their license expiration date, and they will not renew. Number 40, case number 2012025-132. Commission previously authorized a civil penalty against this licensed salesperson who is respondent. $500 of that penalty was from alleged deceptive acts of selling a vehicle that was purchased at an auto auction and disclosed as having unibody / what indicates is RCKR-DMG, which is rocker damage is what that is trying to indicate, which is the lower body panel. This was not disclosed to the consumer. 2 years later, the consumer obtained a Carfax which indicated that the vehicle was sold with structural / frame damage, which is significantly different than what was announced at auction. After review of the auction documents, it's apparent that the Carfax report obtained by the purchaser was not accurate. The vehicle, when purchased at auction, did not have damage to the structure of its frame. It was a dent in the vehicle's rocker panel, which was repaired before the sale. The vehicle's history does not indicate an accident. As such, the respondent did not intentionally withhold knowledge of any type of frame or unibody damage. The remaining $500 of original civil penalty was for off-site sales, which is not subject to what I'm representing to you today. I recommend that we would amend the previous authorization from $1,000 civil penalty to $500 to be settled by consent order or formal hearing. Number 41, case number 2013-007231 and 2013-008721. These are no longer representations. I'm finished with those. These are all cases that I'm first bringing to you now. The above complaints were internally generated after respondent dealers received a notice of violation during a biannual inspection, which indicates that the respondent failed to renew or post its city and county business license. Recommended authorization for a civil penalty in an amount of $250 to be settled by consent order or formal hearing. Number 42, case number 2013-006631 and 2013-009191. These two complaints were internally generated after respondent dealers received notice of violation during a biannual inspection indicating that they failed to maintain its temporary tag logs. I recommend an authorization for a civil penalty in an amount of $1,000 to be settled by consent order or formal hearing. Number 43, which includes 7 cases, 2013-006601, 2013-006621, 2013-006691, 2013-006731, 2013-0051, 2012-013141, and 2012-005671. Here, all of these above complaints were internally generated after respondents' dealers received notice of violation during a biannual inspection indicating that a violation of the Commission statutes and regulations had occurred. However, these notice of violations were not supported by sufficient proof showing the violation. I recommend that they all be closed. Number 44, case number 2013-006581. The above complaint, this complaint was internally generated after respondent dealer received notice of violation during a biannual inspection, indicating violations of the Commission statutes and rules. An agreed citation was sent out to them, and it was not paid or responded to. I recommend an authorization for a civil penalty in an amount of $1,000 to be settled by consent order or formal hearing. Number 45. Case number 2013-006581 and 2013-006611. Above complaints were internally generated after respondent dealers received a notice of violation during a biannual inspection. The inspections were performed in July 2012 and an agreed citation was not sent to a dealer. I recommend that we close these with a letter of warning based on their age. Number 46, case number 2013007981, 2013006561, 2013007801, and 2013003751. All of these above complaints were received stating that the respondent dealers failed to provide titles or registrations for vehicle purchase, or that the dealers had been issued a citation which was not paid. All these dealers above have abandoned their location or are no longer operating. Surety bond information has already been sent to the complainants regarding these. I recommend that we close and flag that the respondent is out of business. Number 47, 2013-004741, 2013-010831, and 2013-211. The above complaints have been settled between the parties. After filing the complaint, I recommend that we close these. They've been settled between parties. And the last case, number 48, 2013-007041, 2013-007991, and 2013-004311 and 2. All of these complaints were withdrawn by the complainant after submitting them to the Commission. I recommend that we close these as being withdrawn. That concludes the legal report for.
Any questions on the report? That being
Number
none,
16, your written $5,000 and your numerical $3,500 don't match.
On number 16, what I've done is I've recommended $3,500, and then past that is a breakdown of where we got to $3,500. It's $2,500 plus $1,000.
It says 5,000 just before the 3,500, doesn't it?
Okay, I understand. We made a change, and I thought you all had gotten that change. I apologize. Yes, that number 16, if that's reading $5,000, and that should be changed to $3,500, where it's written out. It should be. I'm recommending $3,500, and I apologize for that.
Question on 17.
Yes, sir.
Is there any penalty option there for allowing the dealer to buy with no license?
Yes, on number 17, the second recommendation, which is 2972, is the auto auction, which is a $500 civil penalty against the auction for allowing them. Yes, sir.
to 5 a.m.
We'll convene our meeting at 10 o'clock.
Not a bad idea. Yeah.
Chairman, thank you for having me. Appreciate you.
Thank you.
Hey, did you look at that, annual solid waste analysis? I don't really know what is required by TDEC and by Utah.
Right up 10. Do we agree that it's 10 o'clock?
Yeah.
Consensus on that? Leave that as it may. We'll convene the meeting of the July 15th regularly scheduled Tennessee Motor Vehicle Commission meeting, 10 a.m. Director Stribling, would you have roll call, please?
Here.
Here.
Here. Here.
Here. Here.
Here.
Here.
Here. I think that Commissioner Murray and Commissioner McNabb are in the building. Okay. Okay. Get them in and checked in here. Director Stribling, would you acknowledge that Commissioner McNabb and Commissioner Murray are here? I guess let's do a special roll call.
Here.
Thank you. You have the minutes to the last meeting. If you would review those and see if there are any changes that you recommend, or if you'd like to approve them as written. January 14th or 13th on the in the minutes. The declaratory order is for the January meeting of 2014, but the minutes say 2013. Action and a change, I think. Patient time? We have a motion to approve the minutes of the last meeting with the correction to the reference of January 13, when it should have been January 14 for the declaratory hearing. This motion was seconded by Commissioner Clayton. All those in favor say aye.
Aye.
Those opposed? Okay, minutes have been approved. The agenda went out in advance. You should have had time to look at that. We need to get our agenda approved. Motion to approve by Commissioner Clayton.
Commissioner Jackson, second.
Commissioner Jackson seconds the motion to approve to adopt the agenda. All those in favor say aye.
Aye.
Those opposed? Okay, that carries. Before we get into the license appeals, Myrtle's wife, Anita, went into emergency surgery yesterday at St. Thomas. Pearl, Ms. Pearl, in our thoughts and prayers. And Commissioner Billy Keck continues to, I guess, rehab his health. He's had a serious condition that not allowed him to be here. He hopes that he will be here at the next meeting, so we will keep him in our thoughts and prayers as well. Okay, we have quite a number of appeals this morning. Is there anyone that has impending conflict, emergency or something where we need to shuffle this deck a little? Any attorneys have to be in court in the next hour or two? Okay. First appeal is Ransom Griffey, East Tennessee, Nissan, Morristown, Tennessee. Griffey, yes, sir. If you'd like to just, or which is Mr. Griffey? Okay. Are you his counsel?
I am.
Okay, sir.
Good morning, Commissioners. I'm David Changus. I'm here representing Mr. Griffey in East Tennessee Nissan. Mr. Griffey's application was denied pursuant to Tennessee Code Annotated Section 55-17-114A1C on the basis of a prior criminal conviction for possession of less than a gram of cocaine. The statute is pretty clear that the crime has to be one of moral turpitude. And though that phrase is not technically defined by our courts, it's pretty clear that this conviction, which I think was made in January of 2009, does not involve, this is not a crime of moral turpitude. The courts have defined such a crime as an act of baseness, vileness, or depravity in the private and social duties which a man owes to his fellow man or to society in general, contrary to the accepted rule of right and duty between man and man. We submit that the possession of cocaine, while Mr. Griffey is very sorry about that, does not qualify under the statute as a crime of moral turpitude such that his license should have been denied under this statute. That is the only basis for the denial pursuant to the Commission's findings. Just a few examples of crimes that are not considered crimes of moral turpitude that we would submit are similar to this. DUI is not. Involuntary manslaughter, selling beer to a minor. Those are not crimes of moral turpitude. Crimes of moral turpitude would include things like first-degree murder, theft, things with some depraved act involved. This is our position that simply doesn't fall within that category, and as such, we would request that his application this appeal be accepted and his application be granted. I'd be happy to answer any questions.
Agree or disagree with the reason?
Mr. Chairman, I would agree with counsel's statements that he made, and I would recommend that the Commission approve the license of this applicant, based on the fact that there is not discretion to be had, that it is not a crime of moral turpitude.
Commission have questions for counsel or
Commissioner Jackson, I motion that we accept the recommendation of the staff.
Motion by Commissioner Jackson to accept the recommendation of the staff to grant a license. Seconded by Commissioner Fox. Any discussion of the motion? Hearing none, the chair calls for roll call vote.
Yes, is give him his license, yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
Yes. Client will be granted Mr. Griffey. By the way, which is Mr. Griffey? Mr. Griffey, good luck to you, sir.
Thank you, Commissioners.
Thank you. Gregory Benson, Lance Cunningham Ford, Knoxville, Tennessee. Sir.
Good morning to the members of the Commission. My name is Tim Householder. I'm the attorney representing Greg Benson and Lance Cunningham Ford in this appeal.
Which is Mr. Benson, please.
Mr. Benson.
Mr. Benson, welcome.
I have with me also the General Sales Manager, Jason Owens, from Lance Cunningham Ford. As Mr. Changus, my colleague, so deftly stated in the prior case, this is also a case where my client's application was denied pursuant to Tennessee Code 5517-114A1C based on a prior felony conviction, and likewise, this was also a drug conviction occurring in Indiana in 2008. Mr. Benson applied in 2010 and was denied and did not appeal that denial, but upon counsel, I advised him to reapply and be denied and come and appeal this and come before this commission and ask for the opportunity to go back into the business which he loves so much, the actual selling of cars. He's been employed by Lance Cunningham Ford now for some 3 years, doing internet marketing, in information technology, and that kind of work for Lance. But this is not a case where Mr. Benson did anything that was vile, base, or depraved, as most legal definitions of crimes of moral turpitude come to. Instead, Mr. Benson had an addiction problem. He was in possession of methamphetamine because he used it. And this is a case where Mr. Benson has voluntarily undergone treatment since his release and remains committed to his recovery and to the assistance of others in the recovery, in their own recoveries. We've submitted letters from his AA sponsor and for Eagle's Nest for Recovery Living, a facility in Knoxville where he still does a weekly group meeting with people that are inpatient at that facility at this time. And he conducts those groups. This is volunteer work that he does for his commitment to his own recovery and his commitment to other people's recovery. So I won't get deep into the legal argument, but as Mr. Changus stated, a mere conviction for drug possession itself is not a sufficient legal basis to deny Mr. Benson his license to sell cars, and we would move that the Commission take a vote and allow him to regain his license to sell.
From our counsel, please.
Chairman, I would agree that this conviction, possession of methamphetamines, is not a crime involving moral turpitude. As such, I would indicate that the Commission, in my opinion, does not have the discretion to deny the license.
Does the criminal record indicate that's the only charge? There was no
Yes, that was the only
charge
charge.
of theft or anything like that?
No.
Any questions for our staff or for the applicants? No discussion is needed. We'd entertain any motion.
License.
Commissioner Jackson, second it.
Motion by Commissioner Schaefer and seconded by Commissioner Jackson to grant the license to this applicant. Any discussion of the motion? Hearing none, Director Stribling, would you have a roll call vote, please? Yes.
Yes.
Yes. Yes.
Yes.
Yes.
Yes. Yes. Congratulations, you'll be granted the license.
Thanks, sir.
You're welcome. John Layton, AAA Auto Sales Incorporated. And you are Mr. Layton?
Yes, sir.
Okay. Would staff give its reason for denial of this application?
Layton was denied because he had a felony conviction of vehicular homicide. I have my office, along with the help of Mr. Romano over to my left, who, as you all earlier did not, the other commission members did not get to see him or be introduced to him. He's an extern from Belmont University. He's done a great job of helping us out for the last month and a half, and working for free while doing it. And we do appreciate the assistance he's given. But we did some research on this, and it appears that Mr. Layton's conviction was for vehicular homicide, and based on the type of crime that he was convicted of, this crime does not include any type of baseness or vileness in order for the occurrence to be made. Therefore, in the opinion of the legal commission, I would indicate that this particular charge is unlike a reckless charge. This does not include a crime of moral turpitude, and I would recommend that the commission does not have discretion for the denial of this license.
I wanted to, Commissioner Clayton, would you speak to that, please?
If the conviction doesn't have a responsibility, then why is he here?
Here because the commission has a current policy that indicates that any salesperson who provides an application where there's a felony conviction, that person must be denied by Mr. Leon's staff, and it has to come before the commission. That was a policy created in 2007 that has not been amended.
Clayton's point, and I agree with that. Whether or not we grant the license and whether or not this is moral turpitude is one factor. I disagree with the fact that we don't have authority here for granting licenses. I wouldn't usurp that authority for the commission under any circumstance or the licensing authority. I personally feel very strongly about that. Apparently, Commissioner Clayton does as well. So that this is subject to some debate, but my understanding is that a license can be denied as long as it's a valid reason by the full commission. I do understand the point of the staff makes about the public public being at risk for this. Mr. Layton, could you tell us vehicular homicide? Obviously, a terrible accident incurred. Anything to this other than a horrible accident?
I'm not sure what your question is, to be honest
Well,
with you.
my question is there, all we're hearing about this is vehicular homicide. I'm not real familiar with, I hope none of us get, that's some type of horrible accident where someone was killed.
Yes. Yes, sir.
If it's an accident, there was not any intent. You didn't mean to go out and have this horrible accident. And I think that speaks to the staff's point that there was no
One says DUI, one says vehicular homicide.
Tell us what happened, Mr. Layton, if you would.
Yes, sir. I was driving late at night, and I was on the interstate, and the lady in front of me was in the far lane, and I was in the center lane, and I was driving, coming up on her, and she came over in her vehicle in front of me, and I ran into the back of her, and the cars spun out, and her husband, no, her brother, was the gentleman that passed away of a brain aneurysm 3 or 4 days later after the accident had occurred. And that's when I had to go back downtown, and I got charged with that. He refused medical help at the scene, and I don't think there were any signs of him having any sicknesses until the brain aneurysm happened, and I'm not really sure how all that went down. So, but that's pretty much what happened.
Staff agree with that?
DUI associated with that? It looked like it was 2 different dates.
Separate incidents and years apart.
Do you have a driver's license now? A motion to staff recommendation to grant the license, or a motion to not grant the
Commissioner Jackson, since I've heard the explanation from the licee, accept the staff recommendation of granting him his license.
Second.
Mr. Jackson makes the motion to accept the recommendation of the staff to grant the license, and Commissioner Cricket seconded. Any discussion of the motion? Hearing none, we'll call for a roll call vote.
Abstain.
Yes.
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 Yes. Yes.
Yes.
Yes. Layton, you'll be granted a license.
Thank you, Commissioner.
Congratulations, sir.
Back to what Mr. Clayton said, it seems that y'all have a conflict in what is legal in your instructions as to who can get a license. Is that something that should be changed? And how would we go about changing it?
Update the policy, really, that would allow Mr. Strebling the discretion to grant those licenses where on legal's advice it does not include a crime involving moral turpitude.
I'd like to make a motion that we do that.
Rules Committee needs to meet.
Comment?
Rules Committee, it sounds like it needs to go through the Rules Committee first.
I would agree with that. However, we have a motion, we have to see if there's a,
I don't think it would require, well, I don't think it has to go through Rules Committee as far as like a legal standpoint, just for a legal standpoint. I believe
I
it's
think it needs to.
okay, yes. So long as there's clarification on that.
I'm sorry?
I think it needs
My recommendation is to assign the Rules Committee to take a look at that, work it through a process, and 'cause I think it requires some however, we do have a motion. If there's not a second, it would die from lack of a second. Can we repeat that motion?
I recommend that we give the staff the authority to interpret what we can deny a license for, which, I mean, we've had three people up here, which at great expense to them and a lot of time to the staff, that we couldn't legally deny it, is the way I interpret it. So it was a big waste of our time, it seems to me.
It takes on a lot of points of view with that. I think several on the committee, I'm not speaking for anyone, but I would think that there is some sympathy for streamlining the appeal. However, it becomes procedural. There are different points of view on these things, and I think that unless we have a motion that we discuss and do it, I think that would. Motion always takes precedent, I guess, over an agenda, but don't have this on the agenda, and I think it needs some work. I'm in sympathy with what you're saying, and I think there might be others. I think the staff certainly might feel that way, but I think we should consider it. I'd like to see it go to rules.
Could he amend his to get it to the rules?
We can do that, or I think the chair could assign it to the Rules Committee. I'd like to make the motion that it go to Rules Committee.
I'd like to make a motion that goes to the Rules Committee.
Everyone understand the motion? All right. All those in favor of the motion say aye.
Aye.
Those opposed say no. Motion carries. Thank you, Commissioner Paul. All right. Mr. Chauncey Gray. Exchange Sales and Leasing Memphis. Welcome, sir. The staff denial, reason for denial, please, sir.
Mr. Gray was denied based on a felony conviction of conspiracy to possess with intent to distribute, which we believe was cocaine. And in the opinion of legal staff, that this type of conviction involves a crime of moral turpitude, or may involve a crime of moral turpitude, because it has to do with the distribution of narcotics, which can be considered to be an attempt to well, I'm lost for words. Thank you. I have them here. To corrupt moral society.
Nice job, sir. Nice assist. All right.
I believe the commission does have discretion to deny the license if you see fit.
Mr. Gray, would you like to address the commission as to why you would hope that this denial would be overturned?
I have recommendation letters and some stuff from, may I pass them to the
I'd
members?
like to pass those out to the commission, sir. If you would, start with Commissioner McNabb. Are those all different ones, or are they all several copies of the same ones? Okay. We'll just pass those around then.
I'm here in
Proceed,
reference to Statute Code 5517-114A1C. Auto Exchange is a company in Memphis that wholesales cars, and I owned the California cars prior to going into federal prison. I spent 19 years there. Just released in October of 12, but didn't get released from a halfway house until April of 12 this year, so I didn't finish my sentence till April 12. So, sir, I've spent the last 19 years rehabilitating myself, speaking to young men in the institutions and the prisons. Since I've been out, I've been interviewed by several news organizations back in Memphis. One, Mary Beth Conley, the Mary Beth Conley shows, Channel 3 back there in Memphis, talking about trying to stop some of the violence and trying to give some insight from this side on what politicians and people in the city need to do where we come together, create job banks, that type of thing. And some of the disabilities that felons have to go through. Some of the things that we have to overcome. You have voting rights. You also have job employment, that we have to hurdle. And I think my entrepreneurial skills lends credit to the fact that the 19 years have seasoned me. I've been through a lot. I suffered, lost my family. I lost my father while I was locked up, my mother. Kids that are estranged from me. So the years I've gotten rid of some of the things that I've been through. And I made a turnaround. I came out and got a survival job. I gained gainful employment with Allure Bridals. You'll see that was the second letter. My best friend owned that company. He's probably one of the biggest bridal businesses in the country. He trusts me. He has supported me through my incarceration. Everybody that has written a letter in this folder has been on my side and tried to help me overcome the things that I was prior involved in. And my guy at Allure Bridals, Kelly Crum, who owns it, he's trying to help me get into the wholesale business, back buying and selling cars where I can be self-sufficient and possibly within the next 90 days open up another car lot where I can start hiring some of the felons and some of the people that are having a hard time. Because the only way we're going to get these guys off the streets is to make them gainful employment, give them something to do, and lurk behind corners or wait for you to get your car, or wait for some kid to come through the park, get mowed down, something, deranged act. If they and money can't be made for felons, then they have pretty much no choice. They do what they do. But I'm not making excuses, but what I'm saying is we all need jobs. We all need gainful employment. And the only way to get back into the job market, get back into economics, is to be gainfully employed. I can't make it on a survival job. My skills are buying and selling cars. My skills are speaking to people, speaking to groups, and trying to get them to do some things that can change, not just warehousing individuals, but also educating them and getting them funds for computers. I've got some things I've got online with other companies, but I need some help. I need some people like you to trust in some of the things. I don't think that the drug crime that I was convicted in, there was no actual drugs, there was no actual money. It was just the agents trying to come and sell me drugs, and I didn't bite. 2 years later, they indicted me for attempting to purchase those drugs. Agents came up from Mississippi and Arkansas. So I never went into the hotel room. I never saw any drugs. I never showed them any money, and I just didn't get a good feeling. I didn't like the deal. I said, you know what, I'm not going to go through the deal. I'm through with it. But the government only had to prove that there was agreement for me to come for them to come from Texas or Mississippi to Memphis, and that I had agreed for them to come there. So there was never any exchange of money, there was never any drugs, there was never anything. But I served 20 years, and you know, I lost a big part of my life. So but what came out of that is a way now to try to help people move forward and help politicians understand what these people go through. You know, I have a degree in criminal justice from the University of Memphis. I've always asked the Lord Savior, how do I use that? So now I've got a way to use it. But my main love is cars. My main love is automotives, buying and selling cars. I've always treated people right, always done what I wanted to have the relationships that I want, and I've done the things that I think that a felon coming out of jail should do, and I'm asking this commission to give me a chance. And I'm thinking, and I look at the statute, I don't think my crime fits in that moral turpitude. Case, I'm making it to you. I'll answer any questions you guys have for me.
Further comments from our legal staff? Okay, any questions?
Commissioner Jackson, yes. This is to our legal staff. I was listening to him talking about contact that were made from Mississippi to Memphis, never no exchange of money. Was the staff able to get any documentation, to look at any transcript, to determine what he's saying is?
No, the offense itself indicates that there was a conspiracy to possess. That statement alone indicates that there wasn't the actual, when that's the charge, it wasn't the actual possession or the distribution of it. He was convicted of the conspiracy. So if you're convicted
to possess,
that's correct. There's a without getting far into it, is that if you conspire to do an act, then you can be punished under the same violations of the act. Similar type sentence. So I wouldn't contest that he did not, that it wasn't a conspiracy. I don't think that's something that I would contest. Whether or not it actually happened, whether or not his story is true or valid, I would believe it as he said it, because the charge here is for possession, that there wasn't actually a charge for actually doing the act. But whether or not that's a crime of moral turpitude, I believe that the way that Tennessee has defined crimes of moral turpitude, that the intent to distribute narcotics could be considered a crime of moral turpitude. It could be, I believe.
I mean, that's not your opinion, but that is the intent of the law of the state of Tennessee. I'm just trying to understand, tying the moral turpitude versus no drugs, but if Stan and I have a conversation, I'm just trying to play devil advocate. If Stan and I have a conversation about bringing 50 pounds of marijuana to Hotel Z, and Stan may be the informant, so to speak, or the narcotic agent, and that transaction never takes place, then I can be charged with conspiracy.
This was 91.
1991, yes, ma'am.
Mr. Webb.
Why are most of these letters not signed?
Oh, they emailed them to me. Most of them, they all emailed them to me. I had them printed off in the hotel. All of them emailed. I mean, you can contact any one of them. And they're all written by these individuals, yes, sir.
Further questions? Commissioner Jackson.
Just to the license. So you didn't.
They overturned the conviction about 2001. District Judge Bernice Donald didn't really like it, didn't buy it, but the appeals court later, 2002, reversed it. So I ended up spending the rest of the time.
You didn't plead guilty to this.
I had the conversation, sir. I don't deny I had the conversation.
Questions or motions?
I'll make a motion we grant his license.
Second.
Commissioner McNabb makes a motion to grant the license. Commissioner Schaefer seconds. Any discussion of the motion? Hearing none, chair calls for a roll call vote.
Yes.
Yes.
Abstain.
Yes.
Yes. Yes. Yes.
Yes.
Yes. Mr. Gray, you'll be granted a license. Congratulations, sir. Good luck with your career.
Make you guys proud of me. Thank you.
Kylie M. Laws. I'm sorry. Oh, yes. It takes a village.
The first thing I noticed, I was like, oh, look at
Pass it. Commissioner Bassey, pass. Kylie M. Laws. Denial was due to
Tried for the conviction of reckless endangerment, which was a felony, and in my opinion, anything that includes a reckless endangerment is a crime involving moral turpitude. Specifically, that there was a recognizable danger to someone else, and they completely disregarded that. That's what the conviction was for. Starting of that is a crime involving moral turpitude because it has to do with some kind of depravity.
question for staff. Here.
Jackson, I motion that we uphold the staff recommendation.
Second. Jackson made the motion, Commissioner McNabb seconded, and the motion is to uphold the denial. So, Director Stribling, that would be yes for denial. Okay, yes for the motion. Roll call vote, please, sir. Roll call. I call roll call vote. If there, I didn't offer discussion of the motion. I didn't hear any. Roll call vote, please.
Yes.
Yes. Yes. Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes. Okay. William B. Massengale, Toyota Scion of Cleveland. Welcome, sir. You're Mr. Massengale?
Sir, I am.
Okay. Would the staff give us the reason for denial?
Massengale was denied for a conviction of theft of property over $10,000, which is, in my opinion, it does involve a crime involving moral turpitude. As such, the Commission has the discretion to deny this license if it sees fit.
What could you describe what you were convicted of?
2009, I was convicted of theft over $10,000 over it was a vehicle. The courts have found me guilty, so yes, I got to say that I was guilty. I sold a vehicle. It was I had sold it, and I had done a bill of sale and everything, and signed, notarized a bill of sale, and the whole 9 yards on this vehicle. And this was a friend of mine who had turned it in as stolen through the insurance company. And then when 2 weeks later, when they contacted me about it, that he had done that, of course, I didn't feel like I was guilty at all with it at that point. And then he came back, and they came back, and this went to court. And because I did pick the vehicle up and sell the vehicle to an individual, I put it on. I'd put it in the paper. And so, you know, I sold the vehicle, and I signed the bill of sale and everything because and so what I had learned with this is that when the bank has the title, that the bill of sale means nothing but you know, I've been punished for this, and you know, like I said, I respect the courts for the state of Tennessee but this has put a big burden on me, and I'm just here to ask for my license to come back into Tennessee. I was denied my license a year ago, and I have been selling cars down in the state of Alabama, and you know, and I'm 144 miles away from where I'm working at selling cars, and I just want to get back home.
Sold this vehicle, were you a licensed salesperson?
Sure.
You did this as an individual?
As an individual, yes, sir.
What type of vehicle did you sell? What year model?
A 2003 Chevrolet Tahoe.
Chevrolet Tahoe?
Yes, sir.
Okay. What year did you sell this vehicle?
Sold this vehicle in 2007.
How much did you get the check for?
$9,500.
What was that vehicle really worth in the market at that time?
That's about what it was worth in the market at that time, was $9,500. Where the theft over $10,000 came from was where he received a insurance check for $14,000 for this vehicle.
This was a friend of yours that had this vehicle?
Or a so-called friend of mine.
So-called friend of yours? Not anymore?
Not anymore.
All right. We'll go back and visit the value of this, and I have a specific reason for asking. 2007, a 2003 Tahoe. Wrecked? Pretty good condition?
A decent condition. It had a dent in the back hatch. Had a little over 100,000 miles on it.
Two-wheel or four-wheel drive?
Two-wheel.
Commissioner
LTZ, or what was it? LTZ Tahoe, do you know?
It was a cloth vehicle. I mean, it was no LT. It wasn't LT. It'd be LS. Would that be right?
7, and it was 4 years old at the time.
That was a 3.
It was a 2003.
2003. What would it be worth just today? Point. If this was an accidental transaction, you're a victim of the system, as you seem to portray this, why are you selling a vehicle at such a deep discount?
That's what he wanted, his payoff on the vehicle. He wanted to sell what he had the payoff on his vehicle is what he told me he wanted for it, and that's what I sold it for. You know, if I never would have jeopardized everything that I had going for me over a commission of $500, is basically what he paid me. I never would have jeopardized nothing. I never would have signed a document with notarized in front of a notary public over $500 to jeopardize everything, you know, that I had going for me. You know, I have 4 kids. You know, I've never. You can look up my history. I've never done anything. I've never stolen anything. I've never been on drugs. I don't even drink. I mean, I've always been as straight as I could be.
You did do this.
But I did do this.
Now, my point being, in 2007, this vehicle could have been worth $15,000 back then, and you're selling it for $9,500. My experience in the automobile business with buying cars at less than market value, you can buy several of them at less than market value if it's a hot car or if you don't get the title. So I question whether or not this was a misunderstanding about the title, that the bank had the title. because why would you do a transaction at $9,500 for a vehicle worth considerably more?
With the vehicle being worth $9,500, he had told me what he wanted for the vehicle and what his payoff was, and that's he was indicating to me he was trying to get out of his debt, and I helped him sell this. Randy Wells, the president of the bank, that's where he had the title at, and that's who had the. I knew that the title was at the bank. I know, I come from a small town. I know the president of the bank. I knew him, that's where he had it financed at. And after it was all said and done, with the guy that I sold it to called me 2 weeks after I sold it to him and said, Bill, I don't have my title yet. So I called Casey up. I say, he hasn't received his title yet. He said, I'll take care of this. And then, so 2 weeks after that is when I was contacted from the sheriff department to come down, and they asked me, said, is this your signature on this bill of sale? I said, yes, it is. I never denied and lied about nothing with the whole thing. And it just threw me off guard.
Part of this is an accident. Your take on this is that this is an accident. $9,500. I think I'd scrape up $9,500 somewhere and make this right before I went to jail for it. I don't see why did it get to this point? Why not just...
I had no opportunity to pay it. I mean, I paid my restitution. I did have to pay the restitution.
I'm talking about when the thing went down, the guy didn't get his title. Why not just...
Before I knew about it at all, I'm sitting in the sheriff's department and an investigation on it. And then at this point, I did not feel like that I needed to come up with the $9,500. When they approached me with it, I thought, well, Casey's in a lot of trouble. I never felt involved whatsoever at the time at all. And then, so it wasn't about going back and paying it back for the $9,500. I felt like I wasn't entitled to pay back the $9,500, at the time. Yes. He was arrested for insurance fraud.
Were you actually sentenced to anything other than probation?
No, sir. I wasn't sentenced to nothing. I paid my fines. I paid everything that I was found guilty of. Paid everything off, and that's pretty much it. Except for it's left me with a huge scar. A scar that I'm going to deal with the rest of my life, of course. And that's why I'm asking for the opportunity to do this. I'm no threat to anyone, and you can. My record shows. I mean, this is the only piece of trouble I've ever been in my life, and I'm deeply sorry that it's ever happened. I mean, I've put a big burden on my family and everyone, and I'm just keep fighting to make it right.
You had any trouble in Alabama? That's where you said you're currently
Yes. selling
cars. Any trouble there?
Oh no. I know. I've had no trouble nowhere except for this, and I choose to stay in the car business. I love the car business. I have a huge passion for it. And to have the opportunity to do it back home is what I really, really want to do. I mean, I'm having to drive 144 miles one way.
Asking you, and may have answered, and I may have missed it. Did you have a license at this time?
No, sir.
Salesman's license. And so, what were you doing for a living at that?
I had a bail bonding business. And then also a farming tomatoes.
Had Casey come to you and say, "Hey, sell this car for me"?
He asked me if I could help selling. He'd asked me several different people if we could help sell it. He had several different things he was selling at the time. He was losing everything he had, and so he'd asked several people around. Like I said, I was coming from a small town. If you know anybody looking for this, I'm selling this. He was selling jet skis. He had boats. He was selling a lot of things, and so I talked with a lot of people, and I asked around and actually run an ad in the paper on a lot of different items that he had, and sold it, and that's what I sold to someone in Chattanooga. But the paper, it looks like that I'm a thief. I've never stolen nothing before in my life, never.
Questions?
Mr. Jackson, you mentioned about this I'm sure when the investigation was going on, and there was a lot of questions being asked, you mean to tell me you call up the president of the bank and you say, hey, what's going on? This person hadn't gotten his title, and he says to you, I'll check into it.
No, sir. I called up Casey, the one who owned the vehicle, and said, he hasn't received his title yet.
Okay.
He said, I'll get it to him. And so I didn't think nothing else about it. It was 2 more weeks later before I was approached about it. What I'm saying about the president of the bank, I knew where Casey had all this stuff financed. He banked at the same place I banked, and local bank. And I knew that the vehicle was financed at that bank.
I thought I heard you say you had talked to the president of the bank.
No, not about the title. That was with the owner of the vehicle.
State's investigation showing this.
We don't get copies of the state's investigation or any of that. Nothing. All we have is the actual judgment that finds that he pled guilty. Theft over $10,000 indicates his probation ends 2015. Is that correct? The probation ends 2015. Yeah, that's the information that we received.
Commissioner McNeil.
Just want to know why it wasn't your vehicle. You sold it for him to receive compensation for selling it, correct?
Ask that question again.
Well, you received money if you sold the vehicle, correct?
Yes.
So why didn't you let the owner of the vehicle do the bill of sale? Why would you have done that yourself?
When he came to me, when I sold the vehicle, he made a check out to me to the vehicle, to the Casey Pendleton, the guy who bought the vehicle. He made a check out to him. So I give him the check, and at the time when I made him to give it to him, he had the person who bought it had a bill of sale written up that he had written up. I signed it where I delivered him the vehicle. I signed off that he gave me a check for $9,500, and we had it notarized, and then I deliver it back to him. And then he was,
to him, who? The owner of the vehicle?
To the owner of the vehicle. Then he was supposed to take the check, get the check, and pay the title, pay the bank off, take the, and then receive his title, then mail it to him. And I told him, I said, it'd probably take a week or two to do that. And he understood that, and that's why we done the signatures and all. And, and so that's, my whole thing is, if I was trying to pull something over on anyone, if I was trying to be, I never would have signed my name to nothing. I never would have done that. And then, so when I go to court and when I'm up on the stand, they said, well, Mr. Masker, did you take this vehicle? I said, I took that vehicle. I took that vehicle. And so, you stole it. Well, no, I took the vehicle and sold the vehicle. And I never denied doing that. And so that's where they found me guilty on, is that I took it on free will to sell it. I never went and broke into his vehicle and stole his vehicle. But I'm suffering from, I'm getting the same punishment as someone who goes down the street and Slim Jims a car and steals a car. And I'm getting that same punishment. And that's, it's took a while to accept that, because, the only thing I got to do is work, is go harder than what I've used to, is to try to accomplish what I need to accomplish with a huge scar on me.
Well, the buyer came with the bill of sale that you signed, is that correct?
Yeah, well, he came, he showed up, and with the vehicle. He owns a business in Chattanooga. Actually, I was at his business. And so he just wrote out, he asked, do you mind to, we hand write out a bill of sale? I said, absolutely. So, he hand wrote it out. We took it and had it notarized, had it stamped. I signed it, and he signed it. Basically like a receipt where he handed me money on something, because he really didn't have anything with the vehicle. Without a title, it was worthless. So that's what he had to secure his investment. And then that's but by me taking the vehicle is what I'm guilty of.
Mr. Bass has a question.
Commissioner Bass, sir. Just a point of clarification. Did the bank still own the car when you sold the car?
The bank owned the car.
Did the bank give this fellow permission to sell the car?
The bank owned the car. He was wanting to sell the car to get the payoff. So for him having permission from the bank, I have learned, what I have learned with this is there's a document you get from the bank to make this transaction. If I ever do this again, you go to the bank, the buyer and the seller with the bank, and everybody's on the same agreement and have the same documents right there to protect yourself.
The reason why I asked the question, I'm from a small town, and I deal with my bank there, and I had a car once, and I went to the bank, asked them permission to sell the car and then pay it off, and they gave me permission. That's the reason why I asked you the question.
Right. And you know, and I have sold my personal vehicles that I've, you know, had a note on with the bank. I have sold my personal vehicles before on a guarantee to provide the title through the, you know, after I receive it from the bank. But like I said, there's a fine. I mean, there's a proper procedure, a proper way you do it. I know that now.
Oh, you I'm sorry.
But you never tried to find out, getting information from the bank or anybody.
At the beginning of this, I mean, when he said I'm going to sell it, the bank owns the title. No, I mean, as far as going to the bank and says,
but you knew
okay.
that he had it financed through the bank.
Yes.
But you didn't consult the bank.
No, I didn't. At that point, I didn't. I really didn't feel that I needed to at that point. I mean, I felt I knew him well enough, and I, you know, knew this. Figured that you know, everything was all legit.
Mr. McNabb.
It was a check made out to.
It was made out to the owner of the vehicle. It wasn't to the bank. It was out to him.
Both of them.
It was just to him.
Are you licensed in Alabama to sell cars?
Yes.
Which?
Bill Penny Toyota in Huntsville, Alabama. Been there for a year and 2 months. But like I said, it's I have no intention of moving to Alabama. I have 4 kids and teenagers, and you know, just to mention the word move, it's not going over well. So, you know, I want to stay in Tennessee. I want to stay in the Chattanooga area.
I think a key thing is that the judge didn't give him any time. You know, he got sentenced to 0 days for doing this, but he did give him some probation, saying don't get into this again. Is a key thing to me.
If we call Mr. Penny in Huntsville Toyota, what would he say about you?
He'd have all good things to say about me. Mr. Penny, Zach Penny would have very good things to say about me. Yeah. Back, you know, Nelson Bowers in Chattanooga, where I'm wanting to go, the owner of the VW store, the Toyota store where I'm going to go, they all have very good things to say about me. Like I said, what it says here on paper does not justify who I am. I mean, I've never stolen nothing. I've always tried to be a good person. And you know, so now, you know, you've got to go harder to be even a better person now with this kind of scar on you.
Further questions?
I'll make a motion we grant his license.
Second.
We have a motion by Commissioner McNabb to grant the license, seconded by Commissioner Schaefer. Any discussion of the motion? I'll say I agree with the staff denial. Any further discussion? Roll call vote, please.
Yes.
No.
Yes.
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 Yes. Yes.
Ash Gale, congratulations.
Thank you very much.
Good luck with your career.
Thank you.
Get my iPad back on. Philip Ashmore, E&S Auto Sales and Repair. Are you Mr. Ashmore?
Sir.
Okay, welcome. You're not counsel, you are, sir?
General manager of the auto group.
Okay, welcome to you, sir. Would you give us a reason for denial?
Ashmore was convicted of attempting to possess greater than 5 grams of cocaine for resale. Given that it's for the resale, I believe that the Commission has the discretion to deny the license based on it being a crime involving moral turpitude.
Ashmore, would you like to tell us a little about the circumstance of your...
I had a friend that was, he was moving shops. He owned his own business, and he was moving shops. And he asked me if he could I would keep something for him, and I agreed to it. When he got in trouble, police came to my house. There was absolutely nothing missing out of the amount that he had given me to hold for him. And it was, like you say, it was over 5 grams, so it considered cocaine for resale. I've been with Auto Group for more than 6 years. I've sent a letter from the owner. I've sent a letter from the probation officer. I've sent a letter from a counselor saying that I've never been in trouble and I've abided by the rules. I go on a monthly drug test for the state, also for the dealership, and have never been in trouble before.
Know what you were holding?
I had an idea. I didn't see it or anything, but I had an idea. I had held several things for him, some wheels and stuff like that, and that was in there. But I've never had used it, never done anything like that, never been in any trouble whatsoever.
What was your relationship with the gentleman?
It was just a growing up friend, and he was moving businesses, and it wasn't ready to move in yet, so he asked me if I could store some stuff in a garage. I live by myself, so I had a large garage that I kept stuff for. He owned a repair shop, auto repair shop.
Have 5.
He had wheels and floor jacks and stuff like that.
What was the cocaine for? I mean,
he sold it.
He was a distributor?
Yes, sir.
And you weren't aware that he was a distributor?
Did you say that you did not know what you were holding?
I had an idea. I didn't see it or anything like that, but he had it in a box.
But you had an idea of what you were holding?
Yes, sir.
And were you aware of the fact that if you were caught holding that, you'd be responsible for it?
No, I didn't. It didn't cross my mind because I didn't think it was going to be there, but for a day or two.
Dealership. What's the name of it?
It's a Long Auto Group in Chattanooga. I've been there for almost 6 years. Cars, automobiles. It's we have Volvo, Mercedes, and Hyundai.
I read the wrong dealership here.
Long of Chattanooga.
Applying for?
I'm just up for a renewal. I've had license for 6 years.
NS Auto Sales and Repair?
Oh, sir, it's Long Hyundai.
Am I on the wrong?
Long Auto Group.
Ashmore. Philip Ashmore. Mine's, for clarification, because I read this into the record, you're Philip Ashmore?
Yes, sir.
Okay. My appeal list says for you ENS Auto Sales and Repair, Nashville, Tennessee.
That's why it's the question. It didn't make sense.
Oh, for the record, you are applying to sell vehicles for?
Long Auto Group.
Okay. Would your sponsor like to address the commission? And you are, sir?
Tommy Nicholas. I'm the general manager of the Long Automotive Group, and Philip has been an employee for many years. We have a letter here from the owner of the auto group as well as myself representing him. He's been an exemplary. Black mark on his record that there has been. We do test our employees. We do so routinely and randomly, and he has always passed everyone the whole time he's been there. So,
Questions for?
Give us a timeline here. When you've been employed by Long Group,
Since 2007,
and when did this occur? We're talking about
2009.
in 2009.
Yes, sir.
Serve any time? What is the conviction on here?
Actually, I was running out of money. I pled guilty just to end it, but I got probation. I had 3 years probation. And I have a letter from my probation
How long
officer.
had you had it in your possession when before
I think
they came looking
I think
for
it was the third day.
So he was trying to hide it then?
That I don't know. I mean, I was never ever involved in any of the his dealings. He just asked me if I would keep some some stuff in my house.
He arrived and wanted it.
Yes, sir.
That means he had told him.
Yes, sir.
You and he are not too good of buddies anymore.
No, sir.
I have one question.
Mr. Schaefer.
On your application, you marked no.
Actually, I did not fill that out. The human resource lady didn't know about it, and she filled it out to renew the license. Her name was Dana something. She's the one that checked no.
Worked there, and the people at the store at Long Group did not know that you got in trouble.
Sir, it was a lady. It was another human resource lady from when I started that came in. She had left. We had a new lady, and she filled out everybody's license form. She filled out every one of them. Pardon?
Sales manager didn't know?
I'm actually the sales manager. The owner, he knew, but he didn't fill out the license. When they came in, she just...
Somebody has some responsibility other than a little clerk, right?
Yes.
You have been in drug rehab before, haven't you?
Actually, since this happened, I did it on my own. Nobody told me to. I just went on my own just to clear up for my children.
Well, I noticed in your application there's a letter from the counseling center where you were in rehab, right?
I signed up for that, yes, sir, on my own. Yes, sir. No, it was an outpatient. Just I would go on my nights off just to let people like you guys know that I'm...
Prove you're clean or to get clean?
Oh, sir, to prove that I'm clean. No, sir. My attorney suggests, do.
Further discussion? Is there a motion?
Make a motion to approve the license.
Mr. Webb makes a motion to grant the license. Maybe a second. Second from Mr. Parr. Discussion of the motion? Hearing none, roll call vote, please.
No.
Yes.
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 Cody L. Warren. Cody L. Warren, Larry Hill Imports, Cleveland, Tennessee. We
My license for convictions of, there are 3 things in here.
motion.
I'd like to make a motion, we uphold the staff's denial of the application.
Second, Commissioner Bass. Commissioner Bass. All those in favor? Yes, certainly. Certainly can.
Are we is the staff or anyone obligated to go back and check to see if that dealership obligated to do anything to that regard?
Without a complaint, it's a little difficult to follow up on that.
That was my only question.
Is that correct, Director Stribling? Okay. Had a motion. It was seconded to uphold the denial. Any further discussion or questions? Yes.
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 Yes. Yes.
Yes. Christopher L. Looper, Rainbow Ford. Christopher L. Looper. Questions? Jackson makes a motion to uphold the denial. Commissioner McNabb seconded it. Discussion of the motion. Hearing none, roll call vote.
Yes.
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 Yes. Yes.
Yes. Yes. Robert Green. Applying with Downtown Nashville Nissan. Is that right, sir? Okay. Mr. Merkel? Good morning, sir. Reason for denial?
Wire fraud involving a sum of money, I believe.
Merkel, would you like to speak to your case?
Yes, please, sir. Good morning, Patrick Merkel. I work for the law firm of Cameron Worley, and I'm here on behalf of Robert Green this morning. Mr. Green applied back in April of last year, came and appealed the conviction, his denial, and that denial or that appeal was denied. He's back here today with an application through the Downtown Nashville Nissan. Mr. Glandorf said it was wire fraud. It happened in about 2009, if I have my dates correct. And he was sentenced 1 year and 1 day. That was done so that he could get time off for good behavior, which he got. He was released from prison earlier than the 1 year and 1 day, and the sentence included a 5-year probation term. He still has 3 years on his probation term. His sentence also included restitution. So far, he's paid $15,000 of the $62,000 that he is ordered to pay for restitution. He is here seeking this license. His restitution is tied to his earnings. He pays 10% of his earnings towards the restitution. So if he is able to improve himself and improve his position, he can pay off his that money that he owes back quicker. He also is here for his family. He's a family man with a wife and 4 kids, one daughter and 3 sons. This incident occurred when he was a branch manager at a place called Pioneer Credit. He got himself in a bad situation. He met somebody online and had an affair, helped that person get a loan. She sent a friend of hers to get a loan. He helped that person get a loan, and then that person came to him and said, I need you to start approving some people, and if you don't, I'm going to tell your wife. He approved approximately 10 loans, but this guy also said that if there was a problem, I will pay these off. Well, he didn't pay them off. The people didn't pay. When he realized it, after realizing how bad the situation was, he went to his manager. He quit. He told him what he did. He's very sorry for what he's done. He's still with his wife. They worked things out. He told them. He came clean, and wants to move forward and move beyond this mistake that he's made. He's previously licensed by the commission. He worked with Alexander Ford in Murfreesboro. After last year when he was denied, he went and actually sold cars in North Carolina for a time, but his family didn't move, and being apart from them was hard, and he wanted to come back. With that being said, we ask for your mercy, ask for you to give him a second chance, ask for him to get his license. Mr. Green was willing and able to answer any questions that you have. I also have the general sales manager for Downtown Nashville Nissan, Art Hill, who's here to speak on his behalf as well. I'll let you ask any questions you have.
Mr. Green, would you like to step forward? You're welcome to make a comment, or if
brought a couple of letters of recommendation, one from our pastor, another from a personal and professional friend, if you'd like to review them, sir.
Yes, would you like to pass those out? Your conviction was 2009?
Yes, sir, that's correct. Okay. I made a terrible mistake. I didn't realize what I got myself into. I've tried to do right. I did not realize what I got myself into. I made a horrible mistake. I tell you and express how sorry I am for the mistake and decisions I made. I'm trying to do everything right now. I work things out with my wife. There's days that go by, they're hard, but we're trying to make the best of it. We've been together for 16 years. We've got 4 children together. Our daughter's 14, and then 4 sons that are 6, 4, and 1. And I made a terrible mistake, and it will not happen again. I'm just asking for your mercy and for a chance. And she was gracious enough to give me a second chance to show that I can be a good husband and a good father. And Downtown Nashville Nissan has given me an opportunity to show that I can be a good employee. Granted, my position will be in the Business Development Center making phone calls and taking phone calls, just to set appointments for the sales associates there.
This is your second appeal?
Yes, sir, it is. I'm coming before this for a second time. Yes, sir.
Last year?
Yes, sir, April of last year. That's correct.
You might have already said that. Okay. Questions for Mr. Green? Commissioner Murray.
In other states, you said you were licensed in North Carolina. Do they have a motor vehicle commission that you?
No, they don't.
They don't?
No, sir. No, the company I work for, they moved me to North Carolina and gave me an opportunity there to work there and sell cars and try to make a living to support my family. But my wife didn't want to move. My children didn't want to move. They wanted to live here in Tennessee. This is home to me. I was born and raised here in Tennessee. And if at all possible, I want to stay here in Tennessee.
Was there a sales or a sales application that you fill out? Are you okay?
Excuse me. That wasn't my question. So you met this person online? Is that where you at work or home or what? Tell me what happened.
Met them online through Facebook.
From work or home or what?
No, from home.
From home.
Yes, sir.
How long ago has this been?
This was back in 2008 is when it started.
How long did it go on?
The affair only lasted a couple of months.
Let me speak. Once again, my name is Art Hill, General Sales Manager, Downtown Nashville Nissan. At Downtown Nashville Nissan, we're real big on pride and integrity of our employees. We feel like Robert represents us to the fullest. We do understand he's made a mistake, but the department we're going to have him in, being the business development department, taking calls and making outbound calls, I don't really think that poses a threat. He will be monitored, but once again, we do trust him wearing our logo because it represents all of us in the auto industry. So we'll do anything, for Robert as well. First of all, respect him as a man and as a family man, and just as an American. He just wants another chance. So hopefully you guys can show him some mercy and give him an opportunity. We back him wholeheartedly, from our owner all the way down to our lowest sales guy. Everybody there respects Robert. So if you can find it in your hearts to give mercy, we greatly appreciate it.
Working there now, correct? Yeah.
Sir. Right now, he's basically just doing dealer trades. He makes outbound calls for us to get cars and to bring cars in, kind of like our utility guy. But we feel as though there's a lot more potential there for Robert to do a lot more.
Questions? Approved, and it was seconded by Commissioner McNabb. Any discussion of the motion? Roll call vote, please.
Yes. Abstain.
Yes.
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 Yes. Congratulations, sir. Good luck with your career.
Thank you very much. I truly appreciate it. Thank you.
Good luck. Christopher Holt, Tom Bannon Chevrolet.
Holt was convicted of breaking and entering, which in my opinion is a crime involving moral turpitude. As such, the commission has discretion to deny the license.
Oh, good morning, sir. Welcome to the commission. And you are accompanied by?
The general manager.
Okay.
Jeff Grossman.
Your name, sir?
Jeff Grossman, general manager at Tom Bannon Chevy.
All right. Would you like to address the commission in regard to your application?
Yes, I appreciate you guys giving me a chance to meet with you. I did make a mistake when I was younger. It was a bad time in my life. I've learned from my mistake, paid my debt to society. I did do 5 years probation, which I've not been in trouble since. I'm off now. I've been off since 2009. So it's 4 years since I've been off probation.
Date of conviction, I know it's on the...
February
I'm looking
3rd,
at the agenda.
2004.
I'm sorry?
February 3rd, 2004.
Okay.
Crime?
Breaking into a convenience store.
Florida?
Rhode Island.
Guess you broke in while it was closed. Guess you'd have to be. Weapons involved in this?
Want?
Bill, like I said, it was a kid. Was curious.
How'd you go about this? You come in through the roof or?
No, front door. The front door.
Just kicked it in?
No, it was a padlock on. It was a lock attached to a bolt. I'm attached to a block. We just took the block off and the door opened.
Motivation for this was?
Young and dumb. I just turned 18.
Are you with you?
Yes, sir.
But he was 18 as well or something. Yeah.
Have you been in any other trouble since then?
Oh, ma'am.
Working? You gainfully employed?
Yes, sir.
What do you do now, sir?
I work here at Tom Bannon Chevrolet.
What do you?
I'm a sales rep. I've been with them for about 60 days.
Sir, you had a comment and it didn't come in the speaker, so in fact, you're welcome to address the commission.
Typically, Tom Bannon Chevrolet and Tom Bannon, the owner, we typically, if someone has been at a felony, typically we don't hire them, but we interviewed Chris, and we were impressed with him as a candidate. He acknowledged on his application to us that he had had a felony a long time ago, just kind of was apologetic of kind of being a kid, making a dumb mistake. Talked to Tom Bannon about it, and we were able to hire Chris. So Chris is married, he has a kid, his wife graduated from Trevecca, so he moved here to find work. He supports them. So when we applied and it was denied, we keep salespeople in training for 90 days. So applied to the commission to appeal the denial. We think with him, and we just would appreciate if you guys would consider the appeal. Our knowledge, he pled no contest, was on probation for 5 years. We found him. He's been off of probation for 4 years, and so far we're happy with his work ethic. We think he's a man of character, and we'd like to have him a part of our sales team.
I move we approve his license.
Second.
Commissioner Cullum made a motion to approve the license, seconded by Commissioner Schaefer. Commissioner Schaefer.
Whatever.
I can't see your...
It says Schaefer, but it's fallen.
Okay, well, I'm just reading the
I know.
the plaque there. All right. Any discussion of the motion? The motion is to approve or grant the license. Hearing none, we call for a roll call vote.
Yes.
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 Yes. Yes.
Yes.
Yes.
Yes. vote to be granted a license.
Thank you. Appreciate it. Thank you very much.
Thank you guys for your time.
Don't see any more cases on the agenda or appeals for salesperson's licenses. We have a dealership appeal. Haddon Motors, LLC, Manchester, Tennessee. Morning, sir.
Morning. I'm John Constantine, owner of Haddon Motors LLC. Actually, I was denied my dealer's license renewal and a salesman's license. I don't know. I may not have done the appeals process right. I'll tell you a little bit about myself. I've been a dealer in Tennessee since 1989 and under 3 different entity names, all within a half mile of each other. I moved across the street approximately this time last year and way underestimated the amount of paperwork and the things involved to get the license switched over. I thought it'd be I moved from 3011 Hillsborough Highway to 3014. Thought it would be no big deal. I suffered some health issues, was out of work for 4 months last year, got back in about December, started working on this process, and did not get it done until May the 31st. And I was denied for selling a vehicle without a license in January.
Speak to the denial.
I just clarify that
Mr. Glendale.
it was denied for a false act of selling a vehicle from a location that was held out as a licensed dealership when in fact it was not. Secondly, there was a denial of the license application because he made a false statement to the commission indicating he had not sold a vehicle since June 2012, when in fact we received a bill of sale from a consumer from January 2013, and also she provided us with a statement that she had been given a dealer tag for approximately 3 months. And we received a picture.
For 3 months, the use of
Correct.
a dealer tag for 3 months.
For at least 3.
Would that dealer tag, if the respondent didn't have a license, the dealer tag wouldn't be valid, is that right?
The dealer tag was still, the same corporation that's here today was the one that provided the dealer tag. So it was the same, the dealer tag was still provided. I'm not so sure as to whether or not there was a valid giving of a tag, but
I was just wondering if the dealer license was not renewed or revoked, and you have a dealer tag left over.
he had a license at the time. There was a license. The license was always there. It had never been taken away from the commission, so there was always a license.
Well, this denial is based on this offense as opposed to a location. This is not a location issue.
Not necessarily. There was 3 different things. The idea being that if you hold yourself out as a licensed dealer at a location that you're not licensed at, there's not a surety bond for that location. That's a false act, holding yourself out as a licensed dealer at a licensed location, because we don't have all of that information. We don't have the surety bond information. We don't have the garage liability insurance for that new location. We don't have that.
All that was in place. I've always been insured. My surety bond was in place. I was just going through the process. And I let a customer talk me into selling a car. I shouldn't have done it, but I've done business with their family for 20 years. And his girlfriend got involved. They actually changed my bill of sale because I explained to them that I didn't have my license. They changed the bill of sale and put a Bedford County address on it and went registered the vehicle in Bedford County. And that's what sparked this. When I got a call from the Motor Vehicle Commission, I called them back because I'd offered, when the lady came by in February to tell me, when I filled out the affidavit, I told her I'd sold this one vehicle. And I offered to buy the vehicle back, which I eventually ended up doing in March or April.
I think the point that our legal counsel was making about the surety bond is that if your surety bond is good only if you're operating from a licensed location. If you weren't approved to sell vehicles from that location, in the event of a claim, your surety bond probably would not have paid a claim. And is that close to correct?
It's possible. I'm not stating that we don't. I'm not stating one way or the other whether or not he had a surety bond at this location. It's the fact that you're holding yourself out as a licensed dealer at a location before you have a license there is false, because people are walking in there assuming that you've been licensed by the state of Tennessee to operate in this location.
At all our vehicles off the front line, we had a sign on the front door that said vehicles are not for sale at this time. We took the license down off the wall. I just let this gentleman talk me into selling this $3,500 truck.
Timeline on this was you were selling vehicles from a licensed location across the street. You decided
for 15 years.
Decided to move across the street.
Yeah.
You went ahead and when you moved across the street, you must have been doing some business, and then you were audited. Investigators found that you were selling there. And
no, sir. And I've never had any complaints filed against me in 25 years. I've never failed any of the inspections that I have. I was in the process. I filled out the relocation application, and then was informed in August that you have to fill out the relocation application as well as the application like you're a brand new dealer. And that one is a doozy. And it took 5 months to get it done.
How do you feel about this
Well,
one?
I think there are three reasons. There are three reasons why the commission could deny the license. Whether or not the denial should happen, that's within your discretion. But it's for providing, for holding himself out as a licensed dealer at a location he was not licensed for. The second one being that he provided a false statement to our investigators saying he had not sold a vehicle since June, when in fact we found that he sold one in January. And the third being that he provided a dealer tag to a consumer for over 3 months, which by statute you can only give one to a consumer for 24 hours. So there are three reasons why the commission could deny the license.
Was there a fine issued for unlawful licensed activity or unlicensed activity? Did it go through the legal commission for a fine?
This morning, yes.
This is one that was addressed this morning?
Yes.
Okay.
So there was an internal complaint that was open that was brought before the motor vehicle commission this morning.
Individual complaint along with regards to the same facts of this denial, or is it something separate?
It was based on this. There has been a complaint that was internally opened based on this.
Okay. And how much fine?
Just for revocation of the license.
Oh, okay. Sorry, we haven't gone through the legal report, so I wasn't familiar with.
This license was revoked.
That was. You've authorized that. It's an authorization.
Broke the previous license that was across the street.
Correct.
That's not any good anyway. As
Well,
opposed
it's still
to
good. I mean, it's still
it's still
good.
good.
It's still there. The license is still good. The license was across the street is still a valid license. What this was denied for was for a new license at the new location.
Actually, the same license. It's the same license number with a new address, isn't it?
Just a matter of moving back. I don't mean to oversimplify this, but he could move back across the street to the old location and sell cars, sell vehicles with that license. Across the street and did business without license, and then stated to the investigator he had not been selling cars from that location.
That's kind of confusing to me. He was in business on one side of the street. There was a vehicle parked on the other side of the street that got sold. And that's what the problem is because he was on the wrong side of the street. Is that the case?
No, there was two other things. There was a new dealership that is now open across the street. That's not licensed. So the investigator went out there, And then the investigators, there's signs on the cars that say, "Not for sale." And she received his affidavit, Mr. Constantine signed, that says, "We're currently not in business. We haven't been selling cars since June 2012. The only business that we've been doing are title obligations." 2 weeks later, my investigator gets a call from county clerk's office. She goes down there and receives a bill of sale from Haddon Motors, and the bill of sale is from Haddon Motors at the location that's not licensed, 3014 Hillsborough Highway. And the bill of sale sells the vehicle, and the date on there is January 2013.
But
But
if
we
he
were
had
just
written it
told that
from- if he had written it from the one across the street, it would be legal. Is that true?
he had actually sold the vehicle from across the location. But the issue here is now we've been provided what we see as a false statement.
I did tell her about that vehicle, and she asked me specifically not to write it on that affidavit. I'd love for her to be here to tell you that. I've been in business for 24 years. I've never had a complaint, never been in a lawsuit. I moved from 3011 Hillsborough Highway to 3014.
Is this the first time you've ever moved?
No, ma'am. But it's been 15 years since I moved. No, sir. I started off as Manchester Motors in 1989, Manchester LKQ Auto Parts and Sales from 1996 to 1999, and Haddon Motors started in 98 or 99 till present. I sold the two previous businesses.
What we're considering here is upholding the denial for an additional location for this gentleman.
And I do have all the proper paperwork submitted as of the 31st for the new location. New bond, new address, everything is done. I went personally and sat down with Ms. Suddeth in this building to make sure that I was compliant with every obligation that I had. And she said I was.
I'm sorry. Well, that was kind of where I was going. Have we found any other evidence of additional vehicles being sold other than this one?
No, just this one.
And that was in January of this year?
That's correct.
Okay.
We authorized a formal hearing for revocation of license at that location. Am I correct?
License at 3011.
All is for an additional location. Now, are you keeping the other location open?
No, sir.
You're closing one location.
Yeah, that's already another business. I leased it to somebody else and just moved across the street. My understanding was I was actually moving the license that I've had since 1998, just changing the address. That was my understanding. That's what my paperwork that I filled out said.
Second location, do you have signage up?
Yes, I've been inspected.
No, I mean, when you sold this car, without it being licensed as a location, did you have signage up? Did it say Haddon Motors someplace?
I can't be, I'm not sure about that because I just came back to work, probably been back a month, started the process. I did move a sign from across the other street that I put on top of my new building, but I don't know if it was up there or not. It may have been on the ground.
Well, I think that the overriding problem with this is an attempt to deceive the staff about your process.
I understand that, but I didn't attempt to deceive. I was very honest about selling this vehicle. I told her, she said, "Have you sold any vehicles?" I said, "Yes, ma'am. I sold one." And I offered the people to give their money back.
Was there not an agreement not to sell prior to this one being sold? Is that what was there? Was there a cease and desist prior to this vehicle being sold?
The way that I received the information is that I received this affidavit from Mr. Constantine from our investigator. It basically says we've had zoning issues. We're attempting to get a new license. We've had all the paperwork to renew except for the bond. He says we are not actively selling cars at this time. The only activity since June was fulfilling title obligations, and this was signed by him in February 2013. The same investigator called me 2 weeks later and said I had a county clerk call me. And I went, and here, they have a customer who was sold a vehicle in January 2013, a month prior to her obtaining that affidavit. So she provided me with a copy of that bill of sale from January 2013, and along with a photograph of the vehicle that was sold with a dealer tag that was still on it. So based on those issues that we have right there, I provided it to Mr. Stribling because it's something for which the commission can deny an application on. Not advocating for the denial or the granting or either or. It's basically that the commission has the authority and the discretion to deny the license based upon that.
Do we also have the authority to issue a fine?
Not at this proceeding, because this is not the legal report complaint proceeding. So this is not there's not a complaint been opened for it.
Point. Is there anything that we have not received or we're still waiting for that would put them in a situation where, taking this out of the equation, that the license would be denied based on the move, or has everything been received and in compliance with? So it's really just the situation here with, not to diminish it, but more of a timing situation about when he applied and when it's actually finally got everything we need, and the fact that he sold one car during that time frame 7 months ago, 6 months ago.
Now, if the denial is upheld, this applicant still has the right to a formal hearing.
I would probably recommend yes on that, since his application is marked as a reapplication.
Does have the right to a formal hearing?
For the renewal, I would say yes, based upon our statutes and the UAPA and how the statutes are written. That he could file a contested case based on the commission making an action which affects him.
Revocation that legal review authorized.
We would either generally send a letter out to the dealer saying the commission is authorized for the revocation of your license. If you agree and want to turn in your license, here's a procedure to do that. If they don't do that, then we would actually file charges against the dealer to have a hearing on all of this for the revocation of the license. However, if that license turned out to have expired by that point in time, so expired and gone, it's one of those that we would generally take back to the commission many times and recommend that we close the complaint out if it's already expired and it's never going to come back.
Already turned the license in. You guys are in possession of it.
Now, if with the formal hearing on this, looking at our calendar, you're looking at next year.
This is a
put me out of business. I really meant that for our staff, but am I?
Right. What would happen is this: is that if there's a denial of this license renewal application, and there's awaiting a formal hearing, then the way the statute is written is that he will be able to continue to operate until that formal hearing. That's the way that that's the way that the statute reads, is that he has a right to continue operating until there's actually a formal hearing to move forward.
Revocation, he didn't have a license to revoke. We're denying the license. Is that right? At this location?
The license at this new location has not yet been granted.
He doesn't have. Okay.
I don't know how the one potato, two potato this would work, but ultimately, it seems to me that this is a situation where, assuming there's been no previous issues with this operation at this location across the street, and it's a timing issue between getting the paperwork done. If there was a violation during that time frame, there should be some kind of assessment of a fine for that particular transaction, which was one in this case, the January. To make restitution on that, get the paperwork done and grant the approval. Normal hearing, to me, we're going to go through the exact same thing in a
I had
year.
part of the same question, and the answer to that was that because this came through legal review, recommended as I'd offer this up, and up to legal if this will fly or not. But thinking about granting a license after 90 days. Let this respondent in terms of the misinformation is not a good thing. But we go through another proceeding for a fine, then we go through possibly a formal hearing to grant a license. Is it possible for us to grant him a license after a 90-day waiting period?
I would generally say no, and maybe I could help you with the scenario, because I think I know where you want to get to is that withholding the granting or denial of license for a certain time period really is not something that's within your statute, within the authorization. So going anywhere past that, I would wonder whether or not that's slightly arbitrary in nature. But what if the will of the commission is to grant a license and impose some sort of civil penalty, then what we could do is during the legal report, when we present the legal report, we have an authorization in that one for revocation of the license. Someone can make a motion and say, no, we don't want to do revocation. We want to impose a certain civil penalty and have a certain civil penalty imposed, and then everyone could vote on that and have that. So then on that license, there would be a civil penalty that's imposed that I could send a consent order out. But it would not affect the license granting. He would, if that was the scenario. But I think that would get to where you want to go.
That's exactly what I was about to ask.
Tell us again how we get there so we can craft this motion.
If the commission, you can vote now on grant and deny the license, and then we will finish this. We'll roll straight into the legal agenda, and what we'll do is when Mr. Jackson presents the legal report, he can present the legal report, and we could have someone next to him have a motion to amend the legal report on that actual case, and then it would be case number item number 6. We could amend that and look for a civil penalty and vote on that.
Mr. Clayton has a question.
Truth of the matter is, if he'd have built this car out across the street and never shown the address on here, this would not be an issue.
Was the place across the street still open? Let's clarify that.
Yes. I operated on
He still
both.
had a license.
I was going back and forth across the street for probably several months.
Had he sold the car there, built it out there, then this would not be an issue.
Unless we receive some information about the dealer tag. The dealer tag was the other. Know how we would have come across the dealer tag.
What would be the penalty on the dealer tag?
Dealer tag, we generally do the commission $500 or $1,000 for misuse of a dealer tag. First time offense.
And a fine for unlicensed activity.
I got one other question as it relates to the bill of sale. Why does it say the actual price was $4,200 plus tax?
I don't know why she put it on there when I reimbursed, and the lady's not who I sold it to. It's a gentleman. I don't know who this lady is that they've been talking to. But when I reimbursed them, they had spent several $100s putting the window regulator in, and so I reimbursed them for their repairs as well as the purchase price and their taxes and stuff on the vehicle.
Well, you reimburse them approximately $4,200.
Exactly, $4,300.
Yeah.
Mr.
Chairman,
Can I make a motion?
can I ask a question, please?
Let me get the question. Commissioner Murray?
Why did the dealer tag stay on the car for 4 months?
Because, I mean, when I let him talk me into selling the vehicle, and I told him, I said, I'm in this process. It might be 2 weeks, might be a month, it might be 6 weeks. I'd rather just give you your money back and not get involved. And he said, well, if you'll just give me a way to drive for 30 days, you know, then I'll just wait because I really want the vehicle. And to be honest, I've been doing it 24 years. I didn't know it was against the law to give somebody a plate for more than 24 hours. I didn't know that.
Before the requested motion, legal counsel, is it appropriate to make a motion in regard to this case now?
Now you can make a motion based on the licensure only now.
I move that we approve his license by fining for the dealer tag. And I don't know whether you can include it in the one motion or not, but I think that we ought to go ahead and prove his license. Has had that one across the street. He could have sold this car across the street, and this would not have been an issue.
What we need to do to complete your motion is to find out from legal what the range of fines is for these two activities, so that and then we pick a number.
Okay. $500 to $1,000 on the dealer tag.
Right.
Now,
What was the other one?
the other one was.
Unlicensed, okay.
I think you ought to bait that. So I just say that the dealer tags.
Motion then.
Motion is that we approve his license for the new location, and that we fine him for $500 for the dealer tag that he put on the car because he extended that. End of story.
A second.
Commissioner Jackson, I think we can, when we go to the legal review, that's why we can do the fine over there rather than, I heard you earlier say we can't fine in this hearing. But when we go to the legal review report, we can do the fining over there.
Right.
So I would hope that you would be willing to, withdraw your amendment and just grant him the license, and then we'll do the fining over in the legal review report.
Yes. If we could do it that way, that would be much cleaner in the way that we
That's
do
where I
it.
got
Just
my
semantics,
motion.
really.
Okay,
But
okay.
That's fine.
All right, what are we doing here? Are we amending the motion? The person that seconded it will have to accept the amendment. All right, and the All right, any more discussion? Roll call vote, please.
Yes.
Yes.
Yes. Yes.
Yes.
Yes.
Yes.
Yes.
Yes.
Thank you for your time, ladies and gentlemen.
Watch for legal review, but just a clue.
I'm assuming I'll receive something in the mail about that.
Yes, sir, you will.
Okay.
Check in.
Thank you.
I think you will. Okay, let me get Director's report. Director Stribling.
This is a question, and I apologize if it's been asked before, and I believe we talked about it once before, but I can't remember honestly what the response was. But the civil penalties update that we show, all the civil penalties that we've issued. At one point, we talked about getting some kind of, I guess, aging on those penalties as to the collection activity of the penalties. Issuing a penalty is one thing, actually getting paid something completely different. So the question is, do we have anything that shows outstanding penalties that we've issued that are unpaid, and then compared to what we've issued and actually collected upon or settled on after the fact?
We don't keep track of that. We can keep track of that, but what we don't keep track of, there was an authorization for a certain amount of civil penalties against a case. What is a total amount of outstanding? Here, the process that we do is this: is that no matter what the civil penalties are, if there's an authorization for a $1,000 civil penalty, what I do is I send a letter out to informally settle it with the dealer or whoever. Say, here's what we're going to allege. You did this. Sign here. Send us a check. A lot of times we don't hear back from them. We hear nothing. The mail gets returned back to us. Well, we wait for it for between 30 and 60 days. We wait to get an answer back. And if they don't answer back, then what I do is I transfer that case to Robin Ryan, who's the litigating attorney, and then they go into her bucket of cases to deal with. And she takes these oldest first and sets them for formal hearing or whatnot. What happens is a lot of times you'll see me come back to the commission saying, we authorize a $1,000 civil penalty against this person, and they've closed, gone on out of business. What happens is that it could 6 months later that this dealership is completely gone and shut its doors out of business, and we find that out later when we're trying to still communicate for them with mail. So we bring those back. But that's something that we can provide to you. We can provide a quarterly report that says, we know that you've authorized this amount in civil penalties, we've collected this amount, and these are the ones that we have outstanding. I mean, we can do that.
I think that'd be valuable to the commission to understand, we're spending a lot of time and effort going through the legal review and issuing fines. And the question is, are we actually seeing any response to that?
Because what's on the disciplinary action report is actually everything that we receive that comes in. And some of these will be recurring. They're on payment plans or whatnot. They provide us with funds every however, but yes, that's something that we can do.
Need to approve the director's report.
Action so approved.
Second.
Action motion, and Commissioner Schaefer seconds to approve the director's report. Let's do it by voice vote. All those in favor of the motion to approve the director's report say aye.
Aye.
Those opposed? Thank you, Mr. Director. Legal report. Chairman Jackson.
The total of, I'm trying to remember how many cases we had this morning. I'll leave that up to the attorney because I don't forget how many cases we had.
Individual cases, I believe it was approximately between 85 and 90 cases that were presented this quarter, which we're caught up, and that's about the number that approximately is going to be presented going forward unless we get behind. But being caught up, that's generally how many are going to come.
We have case number 6 is the one that we've been talking about earlier. We had the legal report committee had recommended exactly what the staff had recommended, and that was authorization for ratification of the respondent motor vehicle license to be sold by consent order or formal hearing, and that was based on the evidence that was printed to us, given to us earlier today. That was number 6 case numbers. It was number 6 case number 20130007671 and 2012016. Recommendation from the staff, and we had approved that recommendation, but now it's up to the full committee to approve that recommendation or come with and some other recommendation. And also we had just one more, and then I think I'll be out of the way. We had on page, it was case number 38, and rather than on page 11, it should 2012003141, rather than 41, it'd be 42. The supplement case 1A that we're gonna have some discussion on, but I think we ought to get number 6 out of the way first, and then discuss that supplement 1A case number 2013005961.
Questions about the legal review, the first portion before the supplemental case that we're going to discuss? Up to supplement.
Number 6, and then we got to have some discussion on 1A. About it.
Making a change to number 6?
Yes, we're making a change to number 6.
And that change was stated on the record, so.
Yeah.
Who's going to?
Will be stated.
Can I make a motion for number 6 on the change?
Do it individually as a line item, or you can approve the whole report with the recommendation that the legal review committee recommended that change on number 6. Is that right?
That's correct.
You can do it either way. You can pull it out and.
Let's pull out number 6 and do
Yeah.
it, and then
Okay,
because
you
you
wanna
got
vote
some
on
comment on 1A. Remember?
Right, but you want to do number 6, then you have to approve the rest of the report, even without the supplemental. We're going to 3-part it,
Okay.
which is okay if you want.
Can I put 2 parts together? And I make a motion that we accept the legal review committee's findings, and then also make an adjustment to number 6 and change the revocation to a fine on behalf of the unlicensed activities for $500, and then $500 fine for the misuse of the dealer plate.
And I second.
Have a motion and a second. Do we need to review? Have a roll call vote for this one. That's correct.
Yes.
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 Yes. Yes. Okay. Motion carries, and legal review report is approved. Have another case.
Yes, case 1A number 201300591. There were a lot of discussion regarding that in our legal review report, and our chairman Roberts had some comments I think that he want to make, but I think if the staff attorney will just kind of give the overview of the full commission as to what this case is all about, and then if there's some questions or some concern, then they can allow you to do that, and then Chairman Robert will have definitely some comments on it. Ready?
We'll give the brief version. I went over, I guess, in detail earlier this morning, but we received a complaint from a complainant who's an ex-contractor with a dealership. The ex-contractor was actually the manager who ran the dealership up to until 2007, and since then they have not been associated with the dealership anymore. And they indicated that he's a safety advocate nowadays. And what he has alleged is that between 2007 and 2012, this dealer, who generally sells power sports, from that 5-year time period, they were selling motorcycles without having open safety recall repairs done on those vehicles. The commission received the complaint just recently, I guess it's been since maybe March, roughly since March, and we received the complaint because the National Highway Transportation Safety Administration issued a $125,000 penalty against this dealership for those acts. Now, the agreement that they signed, the dealership did not admit to actually conducting any of these acts. The dealership did not admit any violation. They did not receive any fault, and the NHTSA accepted that, and the NHTSA decided not to take them to court to sue them for the violations themselves. Basically, what the agreement says is we potentially, well, the agreement says we deny doing anything wrong. The NHTSA says we think you did something wrong, but we'll pay you $125,000 over a 5-year period. So that's what we received. We received the complaint on that. Our office and the Attorney General's office are both looking at the exact same transaction. We received documentation from the dealer. They provided us. They were very candid about providing us with documentations and from their office, and it appears from where we looked at it is that there are approximately 400 violations. There are approximately 400 motorcycles that I think we can see or we could show that were sold without open safety recall repairs being done. Of those 400 violations, 140 of those motorcycles still have outstanding safety recall work that has not been performed. The rest of them, the repairs were either done by the dealership or other dealerships in the area. The dealership themselves state that for the majority of their violations, they occurred in 2007. The bulk of their majorities occurred in 2007, and after 2008 to 2012, only approximately 20 vehicles have been sold without safety recall work being performed. They indicated that they now have a policy and procedure that indicates that here are the policies and procedures. No vehicle will be sold with an open safety recall, and these are the reasons why. Because we have this in place, that in place, and whatever. And anybody who actually sells or attempts to sell one without the recalls being done, they'll be terminated. Actually terminated one of their salesmen for doing so. Also, that some of the violations are not actual violations. What they indicated is that the manufacturer is indicating that no safety recall has been done, but what they stated was that many of these vehicles action done to determine whether or not the work is required. And they said we did the visual inspection and we didn't record that. So they indicated for many of these perceived violations there actually wasn't a violation. However, what they had not shown us was whether or not, show us the name of the technician who could actually state that this is what happened. We did not receive anything like that, so it cannot be substantiated. They also stated that there's no knowledge of any person actually having been injured by one of these open recalls. That have no knowledge of somebody being injured by one of these vehicles. They did state that one person who purchased one of their vehicles died several years back, but it wasn't one of these vehicles that was a safety recall. Also, there's not been a complaint that's actually been filed by consumers, so we do not actually have any consumer. Item has been in the newspaper in the area where it happened, and there has not been a consumer complaint that's been provided to us. It was just a complaint from this one ex-contractor who worked there. So from the perspective of the legal division, we have had open conversations with the attorney for this dealer and attempting to determine whether or not we could create some kind of a settlement agreement that we could bring to the commission to give you a good recommendation. That over the last week has basically fallen apart. We cannot get close together, and then on advice from our general counsel, we determined not to make a recommendation to the commission, that we will provide you with what we think potentially would be violations that we could show, and that you all could have a discussion and make your own determination as what you would like the legal. I stay in constant contact with the Attorney General's office. They are attempting. They're attempting to speak with the dealer on the same issues, and they may possibly take them to a trial for violations or attempt to settle with them, but they have not settled at this time. Earlier, I had posed some ideas of what we had attempted to settle with to the Legal Review Committee, and I think I'll iterate those if necessary, but if not, that is basically the facts that we can show in the mitigating or aggravating circumstances, and I've provided
to Commissioner Jackson's point about what the Legal Review Committee wanted to do. The Legal Review Committee I attended this morning established the fact in that the statement by our staff that we are the sorry, let me grab it real quickly. That is the opinion. The staff is of the opinion the Commission does have authority over such actions. We added to that and are the licensing authority for the sale of motorcycles. With that said, it seems that the main issue here is safety for consumers that are buying motorcycles from this location. I think that in the absence of a specific action by the Commission, the Attorney General's office is very proactive in this. NHTSA, which is federal, has already gotten involved. The Attorney General's office is very proactive in this. There are ongoing considerations and ongoing negotiations, I guess, of a large nature. I think that the Legal Review Committee, I got from this that, I don't mean to speak for Chairman Jackson, but what I interpreted was that as long as the public interest is being upheld and we're sure that the Attorney General is doing an ample job, that that an action is not recommended by, action was not requested by the staff nor recommended by Legal Review. I agree with that, and I asked the Legal Review Committee if it felt comfortable with the chair asking the staff to keep the chair in the loop as far as what the Attorney General's office is doing, what is taking place, that ample protection for the consumers is being provided, and settlements are worked out in that arena. I got the feedback that the Legal Review Committee was comfortable with that. So what I'm going to do is ask that of the staff to keep us, to keep the chair informed, and that does not have the Commission giving up its right to come back in and fine or revoke or not fine or not revoke. We're giving up no rights. We're giving up none of our authority. But the duplicity of what the Attorney General's office is doing right now is probably not the make that request of the staff to let the chair know progress reports on that, I guess. Any questions or anybody uncomfortable with that?
With that said and done, we need a motion at this point to on a amendment report in the review committee in its entirety. Make that motion.
Commissioner Jackson made a motion to approve the supplemental legal report, and Commissioner Trick that motion. Okay. Voice vote. All those who vote for the motion say yes. Yes. All those that are opposed say no. Legal review report is treated and approved. Thank you. A lot of work on that one.
Items for legal to present to the Commission. Chairman, I have two orders for your signature. These orders were, if I could approach and provide these to you, these orders were against $500.
Real well.
And they had signs of Gossett Fiat on that area. So we had a hearing set for tomorrow. However, Mr. Al Gossett himself flew down to see us along with his attorney, and they agreed to exactly what we asked for at the legal review committee, which is they agreed to pay a civil penalty in the amount of $5,000 after the signing of that order. Secondly, they agreed to stop making any advertisements of any location other than its current licensed location at 1825 Covington Pike. The third thing that they agreed to do was to take down the Fiat sign off of this showroom that's actually inside the mall, so that there is no Fiat. It says Gossett, and all of the vehicles that were located inside the showroom are outside of the showroom. Those vehicles are now outside of the line of sight of the showroom. They're just in the general mall area, which any dealer can display a vehicle in a mall. The representative will not be allowed to go near any of those vehicles during mall hours or talk to anybody about those vehicles during mall hours. Basically, all he'll Gossett, where he sells T-shirts and keychains and whatnot. So other than that, there are no motor vehicles in that store location. There are no motor vehicles that and that all has to take place by July 31st. I have a few more items.
Okay.
And they should not take that long. I'm pleased to report that last meeting the commission had charged myself with having a meeting with Mr. Bob Weaver and also Mr. Darrell Noble for legislation for curb stoning, and we have made some progress on that, and we are due to meet back or provide information back to each other by the 20th of July. I just wanted to let you all know that is going well. We're moving. Also, if you all remember from the April meeting, the commission authorized a declaratory order to be had in January of 2014 regarding whether or not certain actions from Kia Motor Americas could be found to be in violation of two statutes that we have against, I believe it's Gary Matthews Kia. After the commission made that authorization, Kia Motors America has sued the commission both in Chancery and civil court, attempting to stop that declaratory order from happening in January. Kia Motors America did not individually sue any commission members, just the commission itself, and it was not so unexpected. It was actually expected that it happened. Mr. Patrick Merkel, his client, Gary Matthews Kia, he's here. His client was also sued along with the commission for that. So I will make sure that you all receive copies of those complaints, and the Attorney General's office is working to represent the commission on that, and I've been in constant. And we will. There are two hearing dates that are scheduled, one for August 9th and one for August 16th on motions to dismiss each of those complaints that were filed against the commission. So I will keep you all updated as to that and make sure that you all receive copies. Last thing that I have is that it may be possible, it may be necessary from the department's point of view to potentially do a summary suspension on a dealer that's located in the Memphis area. And I wanted to get see if some of the commission members, if a majority of the commission members available for a telephone conference on July 30th, potentially for that. This was Friday, last Friday around noon. We received an email that a motor vehicle dealerships in Memphis had received some indictments, some federal indictments, and 2 owners pled guilty to money laundering through their dealerships and also selling motor vehicles to known drug traffickers. So that I think that the potential, the majority of those 2 individuals, their licenses will be automatically revoked by statute within 60 days unless they come to the commission. But what happens is that they still have 2 dealership licenses that are actually still active right now, and they have other salespersons that weren't part of the indictment that potentially could possibly still operate under the commission. So we are trying to obtain documentation from the federal court down in Memphis to review what those pleas were. We may ask some of the commission members to see if they'd be available by telephone conference on July 30th to potentially have a summary suspension hearing. If that actually happens, we will notify you all to see who could be available for that. But I wanted to make sure that all knew about that. And this idea comes from the idea of this comes from the assistant commissioner's office and also from our chief counsels after we received information of this. So. Like I said, it would be telephone conference only. It would not be in person. With that, those are the only items that I have, and that concludes the legal portion.
Earlier, we approved the legal review report. Now we need another motion to approve the remainder of the report. Of Mr. Glandorf's report, do we need to approve that, or we did the legal review?
No, this all right here is just information that I was providing for you. That does conclude my report.
All right. Old business, I didn't see anything. Is that next time? I've lost my agenda. No old business and no new business to come before the commission. Any comments by commission members? Next on the agenda is adjournment. Anybody like to do that?
Yes.
Let's see.
I'm going to race him back to me.
There you go. That is. I'm right. The next item is adjournment. Is there a motion to adjourn? Motion to adjourn. So moved. Hear no opposition. Thank you.